Your Lordship, may I beg to mention item number 4 and 5?
Yes.
Maybe listed after 2 weeks.
After
2 weeks.
why?
Arguing counsel is out of station.
Who is arguing counsel?
Sunil Mao.
Pardon? Sunil Mao.
Yes, Your Lordship.
We have seen him yesterday.
Yeah, he was here yesterday. This morning he left.
Okay. Your good name, please.
Sonam Somu, S. Somu.
Ms. So-and-so, learned counsel, appearing on behalf of Mr. Sunil Mao, learned conducting counsel for the petitioner, submits that Mr. Mao is out of station. Then as such, the matter may be listed after 2 weeks. Fair.
Much obliged.
You inform the other side? Respondent
I will
side?
inform you. I will inform you.
Lordship.
Yes, you have received the paper box?
Yes, Lordship.
So you were ready to argue the matter?
Yes, Your Lordship. Your Lordship may admit this matter and fix it for hearing, Your Lordship.
Pardon?
Your Lordship may admit this matter and fix it for hearing, Your Lordship.
No, it is already admitted.
Admitted, Your Lordship.
What is the question for readmission?
On the last occasion, they prayed for amendment of the cause title, Your Lordship.
They have done it.
Yes, Lordship, we have done.
What to do? You want to argue the matter or will defer the matter?
Your Lordship may fix it for hearing on the next date, Your Lordship.
Next day.
Lordship, then I have a small prayer. Can it be on in next week, Lordship, the hearing?
Next week.
Next week, Lordship. On Wednesday, Lordship, if possible, Lordship.
No. On Tuesday or Thursday?
Thursday, Lordship.
Thursday.
Thursday, Lordship.
Thursday.
Thursday, Lordship.
Heard Mr. Z. Tallo, learned counsel for the appellant. Madam Zini for respondent, state respondent. Number 1 and Mr. Respondent number 2. It is submitted at the bar that paper book has already been furnished to them and the matter is ready for hearing. And accordingly, it is provided that this is the matter for hearing on Thursday.
Lordship, a small prayer. Apologies, Lordship. Can it be on Tuesday, Lordship? Tuesday, Lordship.
Tuesday.
Tuesday, Lordship.
Okay.
Much obliged.
Yes.
Let the matter be fixed for hearing, madam.
Hearing.
Yes.
You received the paper.
Yes, sir.
Lordship, hearing, we had a small prayer, Lordship. We had filed an IA for suspension of sentences.
Matter is ready for hearing.
Yes, paper book is already ready, and since offense is very serious in nature, POCSO under section 6, 20 years punishment. So
Matter is ready for hearing.
Next week, madam.
When?
Lordship, same date, Lordship. Third
Tuesday.
Tuesday, Lordship.
Tuesday. Mr. Same order. Respondent. Mr. Son, you are amicus curiae.
Yes, ma'am.
Mr. T. Son for learned amicus curiae for the respondent and Mr.
G Tado.
G. Tallo. G.
G Tado.
Learned additional quickly for the state respondent. Let's the matter on Tuesday. Oh, hearing.
Like,
Much obliged.
Lordship, in item number 3, the service has been completed for respondent number 2, Your Lordship. Also, we have received the TCR, Your Lordship. In that case, since no one is representing Your Lordship, if Lordship appoint legal aid
Legal aid
counsel,
counsel.
legal aid counselor.
Is there any list?
There is a list along.
Heard, Mr.
MUA.
Learned counsel for the appellant and Ms. Jeannie for the state respondent. Office note dated 2nd of May 2025 indicates that service in respect of respondent number 2 is completed. But no one entered appearance on behalf of the respondent number 2. Accordingly, we limit appropriate to appoint. Madam, you suggest who is regular in
And Dungan, Your Lordship.
and
Dungan, Your Lordship.
Taki?
Legal aid.
His name is there in the list?
है क्या मैडम का नाम है मैडम का नाम है It's not there, Your Lordship. Otherwise, yes, the High Court का लाना. Your Lordship में in that case, J Doji is there, Your Lordship. Jaya Doji.
J. Dozy.
Yes, Your Lordship.
Mr. or Miss?
Miss, Your
J.
Lordship.
Dozy. Learned. Be appointed as a legal aid counsel. To represent the case of respondent number 2. Recessal prepare the
Paper book, Your Lordship.
paper book and list the matter for hearing in usual course. No, not
Deeply.
usual course, as soon as the paper book is ready.
Deeply.
Deeply, yes.
Team resignation regime.
Better taken up use since the other party is not.
Not there for the last two.
On last occasion also.
Mr. Mozumdar has filed a color. That is in the
He
year
already
24.
appeared in this.
Appeared.
He appeared. On record he is.
Heard, Mr. Stockton, learned counsel, learned senior government advocate with the appellant, none appeals for the respondent on call. List the matter on
On Tuesday was.
Tuesday.
Tuesday.
In the event of subsequent non-representation of the respondent, appropriate orders shall follow.
Close.
इधर से करो ना।
On 28/7/2025, High Order dated 26/5/2025. And in view of the submission so advanced by Ms. So-and-so, learned government advocate, raises at least the matter on the date fixed, that is 28/7.
28 July, yes, sir.
May I please, Lordship? Lordship, I beg to mention item number 25, Lordship.
25.
Lordship. Here, Lordship, the leading counsel, attack is out of
Item
discretion,
number?
Lordship. Item number 25, Lordship.
25.
25, Lordship.
My Lordship, I beg to mention item number 11 and 12, Lordship. And for the petitioner in the both matters,
11 and 12.
Lordship.
Mister, your good name, please?
K Mena, Lordship. K Mena, Lordship.
K. Mena,
Lordship.
learned counsel for the petitioner. Mr. Lolan, any objection?
Lordship, no objection. Lordship, in both the items, I will be appearing on behalf of respondent number 4.
Respondent number 4.
Item 11, I have received a petition copy, but in item 12, I did not. So,
Item number 12, we have not received. Furnish a copy to him
Lordship.
during the course of the day. Heard Mr.
K Mena, Lordship.
Learned counsel for the petitioner and Mr. K. Lolan for the respondent number 4 and Madam Ite for
And for official respondent, Lordship, in item number 11, we have filed our affidavit. Sent.
you have filed.
Yes, Lordship.
Ms. Ite submits that she has already filed the affidavit in opposition on behalf of the state respondents.
and I have also already filed.
Lordship, I have received affidavit opposition from respondent number 3 and 4, Lordship. So I'll be filing a rejoinder on those, Lordship.
You will file. You will be filing. Already filed. Mr. Lolan.
Lordship, there is for
Learned
item
counsel for
11.
the respondent number 4 also submits that he has already filed his affidavit in opposition. The learned counsel for the petitioner submits that he may be granted some time to file affidavit in reply. Here is accordingly allowed. Mr. Lolan also submits that he has not received a copy of rate petition in item number 12. That is WPC number 201 of 2025. The learned counsel for the petitioner undertakes to furnish a copy of the rate petition to Mr. Lolan during the course of the day. Lays the matter after
3 weeks, Lordship.
3 weeks. Okay.
Lordship.
May I please, my lord?
Yes.
My lord, I was not aware the cause list has been updated. The erstwhile item number 18 has now become item number 25. My lord, and the same has been mentioned by my friend. I was waiting, my lord, since item number, my lord, 2025, my lord, I have serious on him. My lord, because this is a project of national importance, and my lord will see the last orders, order dated 7th once, my lord, in this matter. My lord, order dated 7th, there is an absolute, my lord, observation made by the court that this is a project of national importance, my lord, and thus, my lord, the hearing has to take place on the status quo order which was passed on 12/3/25. My lord, on the
No,
7/5.
today that matter is not listed before the court.
It is listed, my lord. It was item 18, but the cause list has been revised and overnight, my lord, and now it has become item
Lordship,
25.
Lordship, it was item number 25, Lordship. Lordship, it was item number 25. Now it is been
Item number 18.
Lordship. Lordship here, Lordship, Mr. A. Tatak, he's the leading counsel, Lordship. Lordship,
Okay.
Lordship, so the matter will be fixed on 10th, Lordship.
No. My lord, after 7/5, my lord, it was the same reason which was given that the counsel is not available. Then, my lord, accordingly, the matter was fixed, my lord, on 19/5, my lord.
Learned counsel for the learned counsel appearing on behalf of Mr.
A. Tatak.
Learned conducting counsel for the petitioner. Press for listing the matter. When?
10th, Lordship.
10th.
10th of May, June.
10th of June. 10th of June. Yes, you are for?
My lord, I am for the Power Grid Corporation of India Limited, my lord. My lord, this is a project which is for the defense importance, my lord, over there, my lord. And my lord,
Yes.
there is a status quo order which has been obtained, and after that, the matter is continuously being adjourned for want of the counsel, my lord. My lord, I am humbly praying, my lord, if the leading counsel is not there, my lord, even on 19th, the leading counsel came, a common date was fixed on 28th, my lord, today. My lord may see the order dated 19/5/25, my lord. My lord, in the file, my lord, we have also given one communication received from the defense authorities showing the significance of this transmission line, my lord. My lord, be as it may, my lord. My lord, if they are seeking for 10th, an observation may be given, my lord, that the matter has to be taken up for hearing on the 10th, and the interim orders may not be extended. My lord, how it's happening? My lord, in the file, there is a document, my lord. I am restraining from making a submission of the same on the public forum, my lord. It is this particular transmission line is a necessity.
Lordship, day before yesterday, I have informed them, Lordship.
My lord, they have informed day before yesterday. I don't deny that. I am not pressing for a hearing today, but my lord, my humble prayer is that the matter may be coming up definitely for a hearing on the same. my lord.
When it is to be listed?
Lordship,
When do you?
10th, Lordship, 10th.
10th.
10th of June, Lordship.
Okay, let it be on 10th of June.
My lord, observation may be put in the order, my lord.
This is a list the matter on. Pardon?
My lord, an observation in the order, my lord, that there is an urgency and it.
You are not audible.
Hello.
My lord,
This is a list the matter on 10th of June. Till then interim order pass earlier shall continue.
Daily, Lordship.
my lord, my lord, an observation to the effect that the hearing may take place on the 10th.
20, madam. Here, my lord, the Hindustan Petroleum Corporation has filed its affidavit. Now, questions of facts have been raised, so I need to seek some instructions from my client, whether any further.
But no
I've
one
informed
is
Mr.
appealing for the
I've informed Mr.
Mr. Deepangan, learned counsel for the petition. With consent from the other side, press for listing the matter. When?
Will be after 2 weeks, madam.
After 2 weeks. Okay.
Obliged.
May I, Lordship? Your Lordship, I beg to mention item number 5. Item number 5, I'm from the petitioner, Lordship. In this case, Lordship, the leading counsel, Mr. H.K. Das, could not be able to attend today's proceeding due to held issue, Lordship.
Item number 5.
Yes, Lordship, item number 5.
Item number 4, there is two possible.
Why?
Starting also about.
Okay.
Lordship, matter may be listed on 20 June.
20
June.
June. Mr. Your good name?
Kailan Lamlai, Lordship.
Learned counsel. With consent from the other side, as for listing the matter on
20 June, Lordship.
20 June. Okay, any objection?
No. Obliged.
Yes.
Much obliged, Lordship.
Number 1.
There is one caveat. Caveat will be heard, caveat sense research. Yes,
Yes, I mean, before my lord, I start my lord. Though I'll try my best, my lord, but I am not sure, my lord, whether I will be properly be able to assist this honorable court, my lord. I feel, my lord, my understanding there is complex issue in this case, issue, my lord, involved in this case, my lord. Though, my lord, I humbly try my best, my lord, to assist properly assist this honorable court, my lord. I will try my best, my lord. Now,
no, you see, yesterday you have referred to the decision of Supreme Court in the case of Shyamsundar Sharma.
my lord,
Shyamsundar Sharma,
my lord.
yesterday. There also it has been observed
Yes, my lord.
that the second appeal will lie.
Yes, my lord. Yes, my lord. What my humble understanding, my lord. My humble understanding. Once, my lord, this condonation application is dismissed, my lord. Two contingent will be raised, my lord. Two contingent. One condonation application will be dismissed, my lord. Now that become a order in the main application, my lord. Now in such a situation, my lord, two contingent arise, my lord. Either order is appealable, there is a remedy against that order, my lord, original order. And there may be situation that there is no remedy provided, no appeal provided, my lord. Now, in particular in CPC, my lord, CPC, it is clear, my lord. CPC, two contingent, my lord. One is situation, my lord, when dismissal of, my lord, this condonation is become a order in the main case itself, my lord. If that is appealable order under 43, my lord, the appeal will be live, my lord. Appealable under order 43, my lord, that is what's called CPC, my lord, that appeal will be live, my lord. Now, suppose if order is not appealable, my lord, the revision will be live, my lord. If there is no remedy, my lord, surely, my lord, revision, my lord.
You see, there are two decisions of the Supreme Court.
My lord.
Yesterday I have shown to you, and the other is Shyamsundar Sharma. That is a three-judge bench decision of Supreme Court.
My lord, that is particular CPC, my lord.
Yes.
What are my understanding of this law is, my lord?
Whether
Yes, my lord.
CPC no, you tell me whether CPC is not applicable in Arunachal Pradesh.
That is, that's why, my lord, that is applicable. But in my case, my lord, my case, whole proceeding, my lord, was 1945 regulation, my lord. Therefore, my lord will consider my case in the light of 1945 regulation, my lord. In terms of 1945 regulation, my lord, and in terms of this 2021 amendment, whether any remedy, my lord, is lie against the order passed by the learned CGM while exercising the second appellate jurisdiction, my lord. That is the issue in this case, my lord. If, my lord, if we go through the whole this act, my lord, 2021 Civil Code Act, my lord, if there is a remedy of appeal, my lord, like in under order in terms of CPC, order 43, 1D, my lord, there is a remedy against ex parte
Now, you
decision.
tell me under which provision you have approached the civil judge senior division?
Under my lord, 2021, my lord, 15, my lord. Plus provision to subsection 4 of the section 15 of Arunachal Pradesh Civil Code 21, my lord. Now, while exercising that jurisdiction, my lord, this order has been passed, my lord. Now, if we go into those 2021, my lord, there is no remedy prescribed against that order, my lord.
Whether that was second appeal?
Yes, my lord, second appeal, my lord. Second, what happened, my
That is second appeal.
second?
No, it is your understanding or it is provided in the act?
That is there, my lord.
Where?
Yes, my lord, you kindly turn to page number, my lord. See, I have annexed the act itself, my lord. Earlier, my lord,
You have approached the civil judge senior division Pasighat for exercising the appellate, second appellate jurisdiction.
exactly that. Not under clause 15, my lord, that will this is my lord. My lord, kindly have a look at the provision, my lord, just for a moment, my lord. Page number 153, my lord. 153, my lord. This is my lord, 153, my lord.
Yes.
My lord, will see, my lord. Earlier in 2021, this provision was not there, my lord. Subsequently, by 2020, this has been brought in, my lord. I am reading, my lord, this clause 3, my lord. After the fourth provision to subsection 3 of the section 15, the following subsection shall be inserted. Means the subsection 4 was inserted, my lord. An appeal from the village authority, if agreed by the parties, shall lie before the inter-village territorial customary court or apex customary court by whatever name called, which shall settle the case as per the local my if appeal, my lord. Now, my lord will see, my lord, there will be a decision by village authority, my lord. Appeal lie to the apex customary court, my lord. Now that become past appeal, my lord. Now the second part I am reading, my lord. Provided that appeal against the order of inter-village territorial court or apex customary court shall lie before the court of civil judge junior division, the court of civil judge senior division, my lord. Under this provision, I approach the session learned civil judge senior division, my lord. Now, my lord has seen, my lord, there was a village authority decision that again there was the respondent approached the apex so-called apex customary court. Now, again that I approached the now. If this is in CPC normally under section only second appeal it before the high court, my lord. Now, as this under A, there is a provision, my lord. We have approached under this provision, my lord. Now, after this, my lord, under whole this act, there is no appeal provision of appeal, my lord. Now, in such situation, my lord, when there is no appeal provided, my lord, my humble understanding, my lord, the ultimate remedy will be this revision, my lord.
So CPC will not apply.
No, that also need to be addressed in this case, my lord. Further, there is a one section also, my lord, that it's say my lord, 114 and kindly have a look, my lord. I find there is a so complex, that's why, my lord, I started to say whether I will be properly able to assist this honorable court, my lord. This complex.
That's all right, but why you cannot withdraw this petition and file an appeal under section 100 CPC?
Now, I humbly believe, my lord, my lord, as a officer of this court, my lord, this is pertaining issue, my lord, need to be properly addressed by this honorable court, my lord. Either I'm not saying, my lord, today also I'm not saying only the revision is remedy, my lord. My humble understanding, my let it be properly after it, let it be either a second appeal or
that issue has already been addressed by Supreme Court in number of cases.
no, my humble
including the decision of Shyamsundar Sharma.
No, my lord, that my lord will kindly see, my lord. That judgment come, my lord, because, my lord, against the ex party, suppose ex party decision.
No,
application.
No.
This, my lord, if I'm, my lord, in terms of CPC, I'm totally considering, my lord, this dismissal of limitation, my lord, condition application will become the original order, my lord, of the appeal, my lord, or any dictatorial order, my lord. That will be, I have no dispute to that settle law, my lord. But the two conditions always arise, my lord, whether that is appealable or not appealable, my lord. If appeal is provided under history, like in CPC, my lord, 1D, my lord, ex parte judgment can be recalled, that is appealable order, my lord. Now, in that context, Supreme Court say, my lord, this is appealable, my lord. Now, if no provision is provided, my lord, I have my humble understanding, my lord, if no remedy is provided, if that is not under, in CPC, if that is not under order 33, that is not included in order 43, my lord, then my humble understanding is division, my lord. That is the situation, my lord.
Maybe, but in principle set, always the parties prefers the second appeal under section 100 CPC.
Second appeal, yes.
Yes.
And then other in other issue, my lord, I will kindly invite my lord attention, my lord. Now, if suppose today I withdraw this case, my lord, I need to file second appeal, suppose. Now, in such situation, also one contingent arise, my lord, whether order or disorder by the CGM, my lord, or sorry, civil the senior division, my lord, can be termed as a order on first appeal or order on second appeal, my lord. Now, order by the disorder by the civil the senior division, my lord.
No, cannot be. Cannot be.
Now, my lord has seen, he has exercised second appeal jurisdiction. First order kabang, there are the original degree, my lord. There are appellate court, customary court, apex customary court, my lord. Again, that's civil judge senior division exercise his jurisdiction, my lord. So in that sense, that become a order on second appeal, my lord.
No.
So for that, my lord, this also need to be, I believe, my lord, this also need interpretation by this honorable court, my lord, at page number this egg, my lord, 149, my lord, or 148, my lord. This also need to be some require some interpretation, my lord, in this case, my lord. My lord, may I pray that, my lord? I humbly believe, my lord, this is a serious complex issue, my lord. For larger interest of the bar in the society, my lord, I am also doubt whether I will properly able to assist my lord or not, my lord. If my lord, allow my lord, I will say, my lord, here some assistant of the other bar member might willing and let matter be addressed properly, my lord, wholly, my lord. So that, my lord, some
That is your business.
proper, my lord, issue that would be determined, my lord.
Yes, anything to submit?
My lord, in this case, there is a confusion. First, my lord, Kabang decision was passed on 16/10/2021. And against this Kabang decision, appeal was filed before the interbless authority on 20 and decision was passed on 24/4/2022. And against this decision, the petitioner filed against second appeal before the civil judge senior division.
Second appeal.
Yes.
Under which provision?
Well,
Under which
because first
provision?
appeal was filed before the interbless customary court.
No. Under which provision second appeal was filed before the civil judge senior division?
My lord, appeal memo, my lord, at page number 108, my lord.
108,
my lord.
Whether this section 15 clause 3 deals with second appeal?
My lord, this is appeal from the apex customary court, my lord.
Is it second appeal?
My lord, that's why, my lord, I'm not sure whether this can be termed as a second appeal or not, my lord. I'm also not sure, my lord. But it's in, my lord, Kabang, my lord, then Apex Customary Court, my lord. Thereafter, this court, my lord. This is second, my lord, by the second or even not second, this is second order by the second appellate court, my lord. So whether it is for part of term is a second appellate order or not, my lord, I'm not sure. That happened, my lord will see, my lord, in this case, my lord. Kabang appeal was there, or Kabang was there, my lord, in my paper, my lord. The respondent, my lord, approached GAM Welfare Association, my lord. Now, to that extent also, my lord, judgment is there, my lord. That cannot be, my lord. Now, if that is so, my lord, in otherwise also, my lord, this revision would be maintainable, my lord. When the authority, my lord, has the my lord, the degree, my lord, or order or my decision, my lord, is totally, my lord, without jurisdiction, my lord. And I humbly believe, my lord, there is in this regard judgment of this honorable court also is there, my lord. That is settled, my lord. There cannot be, my lord. This apex, so-called apex code was by the GAM Welfare Association in Kyong, my lord. Now, against that order, we approached the first appellate court, my lord. So, I humbly believe a lay paper other extent, my lord, that also that issue can be addressed in the civil revision petition, my lord.
Why the CPC would not be applicable in the present case?
My lord, CPC is applicable, my lord, as per the section 18 of the Ownership of the Civil Code Act. CPC is applicable in
Then,
this act also, section 18, my lord.
then where is the bar in preferring second appeal under section 100 CPC?
Lord, with the consent of my both brothers on section 15, just try to assist me. I have gone through the entire act, and my observation is already penned in my book, the 75 years of legal evolution in Arunachal. Within a day or two, it will be released in the NRB. My understanding says, see, first, village authority, then thereafter interterritorial. Now, interterritorial village authority, if the appeal comes, it becomes the first appeal order, FAO, and that will be the spirit of section 96. Now, once the interterritorial village council, village authority exercises the appellate power, then the, say for example, from the junior division, it goes to the senior division. Then what happens is, now the interterritorial village authority and the chief senior division civil judge, both are exercising the same power, parallel power. Now, therefore, on contractors upon the objective of section 100, it prima facie to my mind, second appeal will lie.
Yeah.
Yes, second appeal.
No,
will
that's why I am telling him since yesterday.
No,
And
because
I have also given one decision to him yesterday. It is of 2023 decision. The Kaushik Mutually Aided Cooperative Housing Society versus Amina Begum and another. Their Supreme Court clearly says that second appeal
second appeal, but that
under
because
section 100.
otherwise, the purpose of first appeal order from the
Yes.
original decree.
Yes.
And when you are filing any appeal under second appeal, would be section 100. Section 100 of the CPC would mean you must frame the substantial portion of law. So therefore, the act, there is an anomaly in the act itself. The act has not defined actual jurisdictions, because the village authority is also exercising the appellate jurisdiction, and the senior division civil judge is also exercising the appellate jurisdiction. Now, if we intensely go through the objective of section 100 of the CPC, now district and session judge cannot accept it. because it has to be before the High Court only.
Hmm.
High Court would mean there the substantial question of law has to be framed.
Yes, yes.
So therefore, to my mind, I think section 100, second appeal. RSA,
Yes.
regular second appeal. That's what I can assist without malice and prejudice.
No,
to-
even otherwise also, you see the situation here.
That's section.
There is delay in filing the appeal,
Correct.
for which he had filed one application under section 5 of the Limitation Act before the Civil Judge Senior Division. Civil Judge Senior Division refused to condone the delay and thereby dismiss the application, and consequently the appeal file also dismissed, also stands dismissed.
Correct.
That is a decree. And for that decree, against that decree, only second appeal will lie. And it is settled by a 3-judge bench of the Supreme Court also in the year 2005, that against this rejection of
I think, Madam, that
refusing
judgment
to
is
condone the
referred-
delay.
That judgment is
Second appeal
referred
will
in
lie.
one of my case relating to Teju Bazar Welfare Commission.
Acha,
So I lost that case.
acha.
Grateful.
Yes, my lord.
Thank you for assisting the court.
Yes, my lord. Well, yes, my lord. So doing some research, my lord. I also, my lord, was on this only by this judgment, my lord. But yesterday I placed on record, my lord. This judgment of the by this report also only, my lord, compel me to
That
file
was,
this.
in the act itself, there is no provision for filing second appeal.
Yes, my lord. That way, my lord.
Therefore, the revision will lie.
Now, in our also there is no appeal, my lord.
Hmm.
My understanding, there is no appeal against the decision of the appellate order of the Civil Judge Senior Division, my lord. There is no provision for any appeal, my lord, under the 2000 Civil Code 2021 Act, my lord.
No, if we go by the CPC, then it is section 100.
My lord, in that line, my lord, if my lord pass, my lord, I have no surely, my lord. Only this judgment, my lord, of this report, my lord, compel me to file this CRP, my lord.
Tell me what you will do. You want to pursue the matter or want to withdraw and file appropriate application?
My humble submission, my lord. What that I am, my lord. This is, my lord, important, my lord, because, my lord, one in the judgment yesterday I placed, my lord. That also what happened, my lord. Earlier, this was, my lord, withdraw, my lord. In what happened in the first appeal was filed, my lord. Oh, sorry, second appeal was filed, my. Oh, sorry, CRP was filed, my lord. Now, after some discussion, my lord, that was withdraw, my lord. Saying this in terms of this FS court judgment, my lord, ultimately a remedy would be, my lord, a second appeal, my lord. Now, in those second appeal, this judgment come, my lord. By this
Second appeal?
yes, my lord. My lord, kindly, please, sir. If my lord, kindly take up the judgment, my lord. Take up the judgment, my lord. At para, my lord, we'll see, my lord. Page number 5, my lord. Page number 5 of 5. Page number 5, my lord. Accordingly, what happened in this case? Accordingly, learned appellate court come to conclusion that no sufficient cause is shown in condolence delay, my lord. According the same as dismissed, my lord. Like in
Which decision you were referring to?
relying, my lord, this is Maktur Ahmad, my lord. Maktur Ahmad, my lord. Maktur Ahmad, my lord. At page number 5, my lord. Page number 5, my lord. This is 11, my lord. Accordingly, learned appellate court come to conclusion that no sufficient cause is shown to condone the delay. Accordingly, same as dismissed, my lord. Being agreed by such decision, a revision petition section under 15 CPC was prepared by the appellate before this court, which was registered in CRP number 2014. The said revision petition was withdrawn on 5/7/2014. The said order that this is related, my order, my lord. Had such and such land council is such and such is at the threshold such and such senior council submitted by order in this revision petition, the prayer for condonation delay by the present petition in the application, a company memorandum of appeal before the landed update court was rejected. Further submitted in view of the judgment of the Honorable Supreme Court in such and
Which paragraph you were reading?
the order for my lord. This is 13, my lord.
Paragraph number 13.
No, this is part of paragraph 3, my lord. Paragraph 3, my lord. In paragraph 3, this whole page has been discussed, my lord. Paragraph 3, this is point number 13, my lord, in Roman, my lord. Page number 5, my lord. At page number 5. At page number 5, my lord. Roman 13, my lord. Page number 5, my lord. Page has been in done.
Page 65, my lord.
Yes.
This is a damage assessment report, my lord. This is a damage assessment report by the committee. They have, my lord, they have submitted this report violating all principles of natural justice, my lord. We were not represented. There were no experts there to assess the actual damage, my lord. And so this whole report from top to bottom, my lord, is a kind of a manufactured document, my lord. My lord, the state needs to answer this. And before my lord proceeding further, a writ petition 480 was filed by a certain individual claiming compensation that his house was damaged by the Tower of Power Grid Corporation, that is the petitioner. My lord, there were incessant rains. It was an act of God. This person was compensated by the state government. His due compensation was paid to him. After that, as an afterthought, he has come to the court again, claiming an exorbitant damage, which is supported by this report, my lord. This damage assessment report has no value, my lord. It is illegal. It is arbitrary, and no procedure of law was followed, my lord. So, my lord, notice may be issued to this to the state government and reply as to what as to how they have come to this finding and what are the procedures taken. And my lord, in 480, this petitioner, along with, there were other two people who were joined in, who were not a part of the petitioner, who were not petitioners in writ petition 480. So, my lord, notices may be issued, my lord. As of now, we are not asking for a stay of this impugned assessment report, my lord. But my lord, only notice may be issued and the matter may be heard, my lord.
Heard Mr. R. Sharma, learned senior counsel for senior counsel, assisted by Mr.
And Khera, Nitin Khera.
And Khera, learned counsel for the petitioner. And also heard Ms. R. Basar, learned junior government advocate for the respondent.
1, 2, 3.
Respondent 1, 2, 3. And
1 and 3, Lordship.
1 and 3. And Mr. Parme for 2. Respondent number 2. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the damage and assessment report dated 29/8/2022
my lord.
2022. It is to be noted here that white impugn damage assessment report, the respondent authorities have assessed the compensation which what is the name of the person concerned?
My lord, is
There is a respondent number 4.
respondent number 4, my lord.
Four, my lord. Mr.
Tara Tajuk, my lord.
Okay. Respondent number 4. For a sum of rupees, 1,12,33,104
My lord.
only. Where is the petition and the documents placed on record? Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, and 3. Since Ms. Basser and Mr. Parme entered appearance and received notice, however, extra requisite copy of the petition will be furnished to them during the course of the day. Notice upon respondent number 4 be issued by registered post with AD and also by usual process which may wait from today. List the matter after 4 weeks.
My lord, this writ petition 480 of 2023 is similar, arising out of a similar case. My lord, this matter may be tagged along with this matter.
Mr. Sharma, learned counsel for the petitioner, submits that in connection with same subject matter, another writ petition being WPC number
480 of 2023.
480 of 2023 is
480
pending
of
before this
2023.
court. And this matter may be directed to be taken with the aforementioned writ petition. Care is accordingly allowed. Races shall do the needful in this regard. Let's
Much obliged, my lord. Much obliged, my lord. My lord, may I mention, my lord, item number 25 of today's list. That is, my lord, 10 June has been fixed, my lord. I couldn't appear because, my lord, I was on legs in court number 1 in the principal bench. My lord, may hear the matter because they have obtained stay and enjoying stay for such a long time. My lord, we have also filed an IA, my lord, for vacating the stay order. My lord, let the hearing take place on 10/6, my lord, as fixed by my lord. My lord.
IA.
IA, we have filed an IA also for stay,
Yes.
vacating the stay order. So all the matters may be heard, finally heard on 10th of June, my lord, as fixed by your lordship, my lord.
Yes, already we have directed.
My lord, but my lord, they're delaying the matter, my lord. My lord may kindly pass an observation that this matter, if possible, the matter may be disposed of on that day.
Okay, on that day, an endeavor will be made to finally hear and dispose of the
My
matter.
lord, my lord. Much obliged, my lord. Much obliged.
Obliged, my lord.
But I am praying for disposal of this matter. The petitioner, my lord, superannuated as a superintending engineer in the PhD department. And before his retirement, my lord, his initial pay scale verification was sent, that is IPS, my lord, to the Department of Audit and Pension, my lord, before I burden my lord with the annexes. So then what happened? Thereafter, the Audit and Pension Department gives an observation that the petitioner has not passed the account examination as postulated in the CPWD manual. So then, what had happened? An impugn order was, the file was sent to the Finance Department, my lord, for opinion. The Finance Department has regretted. And thereafter, the Chief Engineer, Western Zone PWD, issues an order saying that no, the Finance Department has not accorded approval for your application praying for exemption of the account order. So therefore, your increment right from executive engineer to SE will not be given, and therefore there was a deduction of 4,33,138 rupees, my lord. Now, in this backdrop, my lord, how we have come. Now, the larger question remains on two parameters, my lord. There is a CPWD manual which says if the officer concerned has not passed the accounts examinations and without any mala fide intention, if the increment has been given by the authority, in that even if he attains the age of 57 years, my lord, then there cannot be deduction. And then there is another notification, I'll bring it, my lord. Another notification which says in 2000, the petitioner was given ad hoc promotion as executive engineer. Now, state government notification says executive engineer is not required to pass the account examination. And then in one of the cases, similarly situated person, there was a executive engineer called Tagong Khetan. In his case also, he also did not pass the account examination. Then the personal file of the
person was granted the benefit of one increment.
Increment.
Earlier granted.
So
But
that
after his retirement, this amount was deducted
yes, madam, that
from his pensionary benefit.
benefits. So being agreed. Therefore, my lord, I have one Rafiq Masih judgment that my lord Whitewasser judgment, my lord knows. Then there is a Jogendra Singh in 2016. Then latest judgment I have brought there's Jageshwar Singh, the Punjab and Haryana High Court, referring to this Rafiq Masih judgment, my lord. And in the affidavit, it is very clear. And then thankfully, the Audit and Pension Department has brought all the records which I require to establish my case, my lord. I'll refer to that also before my brother Tapin starts, my lord. My lord, kindly come to... My lord will only mark one date. The petitioner was promoted from assistant engineer to executive engineer on 3/10/2000, my lord. And the account examination was passing of account examination by executive engineer was made mandatory only in 2001. So that this is the quarrel, my lord. Therefore, then now my lord will kindly come to this particular. This is the vigilance clearance that I got.
Page number 32.
18, my lord. That was on 21/12/2022. I got my vigilance clearance. Now, my lord will come to page 19. I was released from service on superannuation on 28/4/2023, my lord, page 19. Then the department made a communication on 7/3/2023, my lord. The chief engineer writes, no, the paper was given to the Audit and Pension Department, my lord. Then on 7/3/2023, my lord, Annexure 3, dated 7/3/2023, the Audit Department writes to the Chief Engineer PHE Department, Eastern Zone, Namsai, checking of IPS, my lord, under revised pay scale 1986, so and so. My lord will kindly mark the name and designation of the officer, serial number 1, the incumbent promoted to executive engineer on 7/10/2000. But there is no record of passing out of departmental examinations prescribed for executive engineer, and he had regularly been granted periodical increments beyond 2 years. This is the bone of contention, my lord. Now he says in the observation 2, the order department says, as per CPWD Manual Volume 1, to earn periodical increment, departmental examination must be passed within the period of 2 years from the date of appointment or promotion, failing to which no further increment is admissible. If to be, my lord, if he passed the department examination, same may be recorded into the service book. B, if he didn't clear the department examination, excess drawn with effect from 01/10/2002. This is one aspect, my lord, very important to note, my lord. Now, what had happened thereafter, my lord, we, against this backdrop, my lord, kindly come to page 22. This is my representation. All those annexures, my lord, are in the affidavit of the respondent 2 and 4, my lord, that I'll bring on record, my lord. We have written to the chief engineer. Well, this I kindly come, well, that I need to read this particular page, observation part.
Page number?
Page number 23.
Yes.
This which we have written against that observation by the department. Sir, I have the honor to inform you that I am retiring on superannuation from government service as superintending engineer with effect from 30th April 2023. In this regard, my service book was sent to the office of the Director, Audit and Pension, Government of Arunachal Pradesh, Nahardigan, for IPS checking. After IPS checking, the Director of Audit and Pension Office has returned my service book on 9th March 2023 with the observation as indicated above. That we will not read. We have already read the observation part 1, 2, and 3. So then 2, kindly come to the 2 also. 2 is important. Kindly refer Government Office Memorandum Number AR 2018, 21st January 2019, included, wherein it is clearly mentioned that the provision laid in para 6(2) of Central Public Works Department Manual Edition 2013 has been amended, exempting the passing of departmental examination, and was circulated with the instruction to comply the government order accordingly. So in that view, that para 3, as per Government of India Director General CPWD Department wide office number so and so, the copy is enclosed in Annexure D, wherein it is mentioned that exemption from passing the departmental account examination will be considered on case-to-case basis. My lord, will kindly mark the Roman number 2, next page, page 22. My lord.
Yes.
Roman 2, the officers should have reached the age of 57 years. Now, once the officer reached the age of 57 years, the riser is, there cannot be no deduction. Even if he has not passed the account examination, then the department is bound to give him the exemption. My lord. That, my lord, will refer. I'll place the judgment in Jagdan Singh case, Jagdeep Singh case, my lord, para 9 and 11, it will cover. Because this has reiterated the law laid down in the Rafiq Masih case, my lord. So, my lord has seen. So, therefore, my lord, in the, kindly come to, my lord, next, after Roman 2, my lord. Moreover, as per the Roman 3, my lord, next para. Moreover, as per the government order referred above in Annexure B, it is pertinent to mention here that the other senior officer of PHE and Water Supply Department who have retired on superannuation on previous occasions was also granted exemption from passing of the departmental accounts exam by the Director of Audit and Pension, Government of Arunachal Pradesh, Nahardigan. Likewise, my appointment as, my lord will mark this is a very important contention I have raised, the petitioner has raised. Likewise, my appointment as executive engineer was done on 25/9/2000, which comes under a grace period up to 2 years. As such, my case also be brought under the purview of the order as already granted to other retired person on earlier occasions under special and humanitarian conditions. 5, it is also mentioned here that my ad hoc appointment as superintending engineer was regularized by office order number so and so dated 2015. Therefore, under the reasons as stated above, I would sincerely request your personal sympathy for issuance of certificate of good records of government service in favor of me on a very special case, so as to enable me to able the exemption from passing the departmental account examination and to enable to get my regretted the proposal for exemption from passing of the departmental examination and relaxation or waiver from recovery of excess payment in respect of Engineer Tamoli Tako, retired SC. So in this context, you are requested to recover. Pursuant to this latter, my lord, this impugned order was issued at page number 24, my lord, kindly see. This is, my lord, they have deducted those money and then everything out of 23 lakhs they have given to me. There is no quarrel on it, but the deduction as remains, my lord. Now, my lord will kindly come to page 28, office memorandum, recovery of wrongful excess payment made to the government servant, my lord. That is 0203-2016 notifications by Ministry of Personnel. And my lord, Arunachal Pradesh, my lord, for the kind knowledge of this court, my lord, the Arunachal government does not have its own service commission, my lord. It follows the CCS rule and all the notifications issued by the Department of Personnel, Government of India, my lord. That part, my lord, on record, I want to bring it, my lord. My lord, what had happened is, this is New Delhi, page 28, my lord. 2nd March 2016, office memorandum, recovery of wrongful excess payments made to government servants. This judgment, my lord, para 2, I will read, my lord. There are so many judgments, these judgments are covered in the, especially, my lord, will see in paragraph 2, Rafiq Masih has been referred to. My lord, to be very fair with the court, my lord, the Rafiq Masih case was group C and D case, my lord. But laying down the law, if wrongly you have extended the financial benefit after retirement or before 1 year of retirement, you cannot recover the excess money paid because of doctrine of waiver. Subject to that, if there is no mens coupled with the mala fide intention to deceive the department. So, my lord, kindly see that paragraph 7 of the Rafiq Masih judgment has been given, my lord. Having examined a number of...
Whether that decision is part of the record? No.
No, that decision is permissible. Certain exceptions is there that I will refer to. My lord, this is important for me, my lord. Para 7 of that, paragraph 17, my lord, that's very important in Rafiq Masih case, my lord. Some exception has been called out, my lord. This is a notification, my lord. Having examined a number of judgments rendered by this court, we are of the view that orders passed by the employer seeking recovery of monetary benefits wrongly extended to employees can only be interfered with in case where such recovery would result in a hardship of a nature which would far outweigh the equitable balance of employers' right to recover. In other words, interference would be called for only in such cases where it would be iniquitous to recover the payment made. In order to ascertain the parameters of the above considerations and the rest to be applied, references needs to be made to the situation when this court exempted employees from such recovery, even in exercise of its jurisdiction under Article 142 of the Constitution of India, repeated exercise of such power. For doing complete justice in any cause would establish that the recovery being effected was iniquitous and therefore arbitrary, and accordingly the interference at the hands of this court. In view of the aforesaid constitutional mandate, equity and good conscience, in the matter of livelihood of the people of this country has to be basis of all government actions and actions of the state. Ordering a recovery from an employee would be in order so long as it is not rendered iniquitous to the extent that action of recovery would be more unfair, more wrongful, more improper, and more unwarranted than corresponding right of the employer to recover the amount. Or in other words, till such time as the recovery would have a harsh arbitrary effect on the employees, it would be permissible in law. Order passed in given situation repeatedly, even in the exercise of so and so, disclose the parameters or realm of an action of recovery of an excess amount paid on employee which would breach the obligations of the state to the citizen of this country and under this arbitrary there. Now, my lord will kindly come to the notification, paragraph 4, my lord. That what I explained to the proposition laid down in Rafiq Masih. My lord, paragraph 4, the government has come out with a notification, my lord. The Honorable Supreme Court, while observing that it is not possible to postulate all situation of hardships which would govern employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement, has summarized the following few situations wherein recoveries by the employees would be impermissible in law. Malad will mark impermissible in law. The Roman one says recovery from employees belonging to clause 2, 3 and clause 4 plus 4 service or group C and group D services. But Milord, the writer in this judgment is, or they have done is, recovery from retired employee. Well, this is applicable in my case. And this is reiterated in the letter judgment by the apex court. My lord will only kindly mark this. Recovery from retired employees or employees who are due to retire within 1 year of the order of the recovery. The law doesn't permit that. Now, this is their notifications, my lord. Kindly come to page 31, my lord. Again, in 3rd October 2022, the Ministry of Personnel, they issue another notifications. I am burdening, my lord. I am sorry, but
Pardon?
I am burdening, my lord.
No.
Para 4, my lord. Kindly come to para 4, page 31, para 4, my lord. To fortify my argument, in this context, it is observed that the time taken by the ministry, stroke departments, stroke officers to discover mistakes, clerical faults in pay fixation of their employees is highly avoidable. The situation of overpayment occurs on account of erroneous calculation of payments due to an employee. If not detected in time, amount becoming due for recovery due to this excess payment keep accruing. In many cases, these overpayments came to notice of the administrative authority at a very late stage, resulting in substantial amount becoming due for recovery. However, in the wake of order dated 18/12/2014 of the Honorable Supreme Court referred above, these recoveries are to be considered for waiver, my lord, in the types of cases identified therein. As a result, the administrative authorities' concerns are compelled to explore other alternatives available to recover the amount involved or seek approval of the Department of Expenditure to waive off the same in accordance with the procedure prescribed in Department so-and-so 2016 notification, my lord, which we have read already, my lord. So these are the measures, my lord, which they have that they said ki they gracefully they say that the waiver, doctrine of waiver will be included because there was no mistake on their part. Now, my lord, without bothering much, my lord, I'll refer to this particular judgment. Kindly have the affidavit in opposition by respondent number 2 and 4. Then I come to my rejoinder, then I place my law.
Yes.
My lord, kindly come to page 68, annexure D. That is 28 August 2017. office memorandum exemption from passing the departmental accounts examinations. My lord, kindly see the right part, amended provisions in the right box.
Page number?
Page 68, my lord, that affidavit in opposition by respondent number 2 and 4.
TN4 or 2 or 4?
My lord, 2 and 4, my lord.
2 and 4.
Respondent number 2 and 4. my lord.
Yes, page
Okay.
number
68.
But
Well, that now there is a new notification by the High Court that it should be continuation of the
yeah.
pagination should be in continuation to the read petitions.
But 68 is the second page of the notification dated 18th of February 2004.
But my lord, 67 type copy is there.
That
My
is
lord, my
annexer, page number 67 is annexer 1 of their affidavit.
my lord, this mine is annexure D. my lord.
D.
D.
No, you are referring to their affidavit.
Yes, their affidavit filed by respondent number 2 and 4.
Yes.
Two and four by the 386s. Huh? Same, mine is my lord is taking up 386 read petition.
Yeah.
Can you take up 386? Muy bien. Next. Golden. This is my like there. Huh? Yeah, you can't think. ये तो बेलेगा 386 लोग 880 उल्टा तो क्या करेगा 56 minutes. It is 56.
56. Okay.
Page करेगा इसलिए affidavit by you, but by you. Durgavati 56. When you given memorandum, office memorandum. जी है क्या? आपका जो दिया है हमको वही हो. हाँ, दुर्गावती तबा है. This is 56. इसको पढ़ा. Second copy तो मुक्ति के लगे पढ़ा. That you start with this.
आपका में क्या?
मेरा में 58 है. 68 है.
Hard copy.
Hard copy. Same.
Yes.
56. अभी लिखे.
Oh.
In any case, मेरा sir. So my lord will come to the right box, box serial number 1, my lord,
Amended provision.
amended provisions. The executive engineer, stroke assistant engineer, stroke junior engineer, and equivalent are required to pass the departmental examination within 2 years on promotion stroke joining the department for earning the second increment. Exemption from passing the departmental examination will be considered on case-to-case basis. Exemption will be granted by a special Director General Headquarters, CPWD. Here, my lord, we do not have the Director General, but we have the Chief Engineer. And the file has wrongly been sent to the Finance Department, my lord. That is also not the correct procedure to be followed. It is within the competency, my lord. If you are saying, Audit and Pension Department is saying that CPWD manual is to be followed, then it is the Chief Engineer. So then what it says, my lord, the officer should have reached the age of 57 years. My lord, absolutely. When I was 59 years old, retirement age in Arunachal for any government service is 60 years, my lord. So I have crossed 57 as well. And the last quarter of 60, my lord, my IPS was sent for checking, my lord. So on the first parameter of this amended provision itself, my case fits into the scheme. Secondly, my lord, the says should have good records of office, my lord. I too have the good record of office because there is no department inquiry, no criminal case against me, my lord. He should have proof of appearing in the departmental account examination. Well, in view of that 2016 notifications, only AE, JE and AEs were made mandatory in 2000. That I will demonstrate from my affidavit itself. So therefore, on this first count, my case can be considered. Now, the most important part is my lord, in their affidavit in opposition, paragraph 11, kindly see. Please, according to you, Tapin, it is 52.
Yes.
Well, kindly come to page 52.
Affidavit in opposition.
There, same, on the same affidavit, page
50.
Page 52, second paragraph. Also, as claimed by the petitioner that recovery of.
No, here again.
Just whatever they have given to me, my lord, I just paragraph 11, my lord, kindly have this. Oh, Tapin, I don't know because whatever you have supplied is found to be correct here. The hard copy. Which one? This are two same 2 and 4. Durgabati cover. Pagination, one of them. My lord will have this paragraph 11, if my lord.
10.
Paragraph 11, if my lord don't know.
Of their affidavit.
Yes, of their affidavit.
Yes.
Same. We have just corrected in your copy is not correct. But otherwise same only. Annexure also number same.
NHS are same, they have not corrected it. Anyway, like, I always consider, we are human, or is human without. My lord, we'll see this second para. Also, as claimed by the petitioner that the recovery of wrongful stroke excess payment made to the government servant would be impermissible in law after retirement or who is due to retire within 1 year. In this regard, it is stated that this office would have pointed out the excess drawl on the time had the service book been sent to this office timely for betting of his initial pay fixation. Well, right. The Audit and Pension Department is absolutely right. However, on the inside, my lord, it is their duty to keep reminding the department. There is a notification, my lord, I remember. There is a notification from the Arunachal government itself way back in 1999. There it says the service book and the IPS, initial pay scale, has always to be verified every year. Unfortunately, there is a blame game. Now, candidly, they have admitted, yes, the department has not sent the file for pay verification. So therefore, my lord, the fault cannot be lied on me, my lord. It is the action of the department who has faulted by themselves, leading me to this mysterious circumstances to face. Now, my lord, that again, just check a page 67 is which page? 55. My lord will come to page 55. Page 55. No, where is this department of 2010? Yes. Type of is 54, my lord. 54. Page 54. Page 54 is the notification, my lord. And then before issuance of this notification, I was given promotion, my lord, that I have already requested my lord to make that. I was promoted on 3/10/2000, my lord. And this notification was issued on 22/10, my lord. Just 17 days after my promotion. So therefore, this notification will not be applicable to me. This is important for my case, my lord. Where is this? Page 62 would be where copying. Page 62. You just check out. Then one more document I will rely on, then I'll come to the file noting. Just in the meantime. Here. My lord will kindly come to page 51. Oh, the same affidavit. This again further fortifies my argument, my lord.
Yes.
It is a notification dated 19 July 2000, my lord. Pursuant to the adoption of norms and procedure of CPW manuals by all works department under the government of Arunachal Pradesh, the departmental examination in respect of assistant engineer and junior engineer in the Department of Public Health Engineering and Water Supply is hereby enforced. My lord, the word executive engineer is not there. The same thing that we have already raised, 68E. Yes, my lord, then the space 69 is open. My lord will have annexure E page 57 for a motion.
Annexure E.
Annexure E page 51 according to
57.
57.
Okay.
This is a 2016 2nd March notification by the Ministry of Personnel. I have one more annexure to relate. Same thing has been reiterated in 2016 3rd March, my lord. My lord will only kindly come to next page 58. My lord will kindly come to page 58 only. Yes, my lord. I would request my lord to indulge to paragraph 4 straight. The Roman 2.
No, you have already pointed it out.
Yeah, my lord. This is what the correction. This is into but that is earlier, my lord. Earlier notification, and this is the 3rd March 2016 notification, my lord. It is reiterated in the Roman 2, my lord. Recovery is not permissible. Now, my lord will kindly have my rejoinder to this.
Yes.
My lord, this page 87, the file noting annexure 1. This is page 75. Page 75, my lord. Just you keep on correcting, okay? In the meantime, I'll read. Page 75, my lord. A copy of, this is file noting, my lord. How my thing was denied and then how they have allowed another person, my lord. The example is also there. That the paragraph, it is seen that the department has submitted his service book for IPS checking to the Director Audit and Pension Government of Arunachal Pradesh, Naharalan, since his retirement is due 13 April 2023, wherein Director Audit and Pension in the service book during the period of executive engineer. Hence, they directed the department to recover excess drawn so and so. Now, in this connection, my lord, kindly see. In this connection, the incumbent was promoted from assistant engineer to executive engineer on 3/10/2000 wide order number so and so dated so and so. So and also promoted from executive engineer superintending engineer on ad hoc on 2011 and regular so and so to the which may kindly be seen as well. Although there is, my lord, this two paragraph is a clinching thing for me. Although there is departmental accounts examination prescribed for junior engineers, assistant engineers, and executive engineers as per CPWD Manual Volume 1, but PHE and Water Supply Department has adopted, it should be typological mistake. It will not be worse. Adopted departmental account examination wide government order number so and so that is 16/8/2000, which is clearly mentioned that departmental examination in respect of junior engineers and assistant engineer in the in the department of PHE and WAS is enforced as per provision of CPWD Manual Volume 1 in toto as per the aforesaid government order. There is no provision for executive engineers labeled to appear departmental account examination, which may be seen. Now this paragraph. In this regard, the excess salary drawn recovery in respect of Tamoli Tako SC does not arise, my lord, kindly see. Arise in executive engineer period with effect from 01/10/2002 to 01/6/2011 till the promotion to the superintending engineer, as he was promoted from assistant engineer to executive engineer wide order number dated so and so. After adoption of my lord, account examination by a public head in water supply, as there is no provision for appearing departmental examination in the aforesaid government order. My lord, next para is important. That is only I request my lord to see. Here, my lord, this is very important. Further, next page. Further, there is provision for exemption from passing of the departmental account examination who have reached the age of 57 years, having good service record as per government order number so and so, dated 21/01/2019, which may be seen it. In this regard, the incumbent has reached the age of 57 years, who is retiring on superannuation on 30th April 2023. And also department has furnished the certificate of good service records of the incumbent, which may kindly be seen. But then, my lord, again, it was sent to the finance department. My lord will only have page 89, page, my lord. My lord will kindly come to 77.
Yes.
My lord will see para 1, 2, 3, 4, 5, my lord. There also they have recorded the same thing. However, as per point number 5 of the said OM, such exemption may be allowed with express approval of Department of Expenditure in terms of so and so, which we have referred to, my lord. There was a recommendation. Next para says it is pertinent to mention here that the similar case for exemption of excess drawal as per above DOPT OM in respect of engineer Bikasnath, retired EE or PhD, was forwarded to Finance Department, which is yet to be received. So now they have sent it to the Finance Department, my lord. Now, Law Department says, Law Department observation, I'll not go through, my lord. I think a page number, I think 94 page. 82, my lord.
Yes.
Now, note number 24, my lord. Government of Arunachal Pradesh Finance Planning. Finance Department regrets the proposal of PHE Department for examination from passing of departmental accounts examination in respect of engineer Tamoli Tako, retired SC, and relaxation or waiver from recovery of excess payment. Madam, this is exactly in contravention to the amended provision which we have read. What is the role of this Finance Department here? The interesting part is annexure 2 of my rejoinder. I'm almost finishing, another 5 minutes to place my judgment.
Page number?
Page number 92. Well, 92 kakatana. Tamoli Tako, letter dated 24 July. This is the one. 87, my lord.
Okay.
My lord will see paragraph box serial number 2 and 3. Office order for exemption from passing accounts examination in or recovery order, if any, in respect of AK Singh, SR Komoth, engineer Tagong Khetan, CE, retired, and Lapalum Kri, retired, my lord. Then in next column, the remark is copy of exemption order from director account pension in respect of so and so, Tagong Khetan is there. Now these particular gentlemen's thing is here. My lord, page 101. Which page? 101 is 90. Page 90, my lord, can kindly come. I am demonstrating from the records only, my lord.
Page number?
90, my lord. I think you have the 90. 90, my rejoinder. Yes. Annexure 3, my lord. My lord will kindly see the letter which they have forwarded. Is 101A, 90. That is annexure 3. Please come. My lord, they said, please refer to the Under Secretary PH and Water Supply Department, Itanagar, Government of Arunachal Pradesh. Your letter number PH is so and so. Please refer your letter number quoted above. The IPS, along with service book of the official, has have duly been checked and are written for the following reasons. 1. Tagong Khetan, my lord, the similarly situated person who was appointed in the same year. On re-examining the service book of incumbent, it appears that the passing of the departmental account exam for AE, the stroke EE, had been made mandatory with effect from 10/8/2001. Now, my lord, I've seen my appointment as executive engineer was 03/10/2000, lord. My appointment as executive engineer was prior to 1 year of this notification coming into force. As the officer had already been promoted as EE before the cutoff date of passing departmental account exam, the question of passing department exam for AE, EE, and recovery of excess withdrawal of pay and allowances therein does not arises as mentioned in the earlier observation white letter dated so and so. DNI, daily net income index, that is a DNI. Of incumbent falling in the pre-revised scale during the month of May 2006 as one additional increment may allot in the pre-revised pay scale, and then the pay may be refixed so and so. This supersedes our earlier observation. Now the same audit department below for the similarly situated officer, but he is superintending chief engineer, but I retire as a superintending engineer below in the same department below. Now therefore, the impugn order is not sustainable for these reasons, my lord. For judgment of legal, like this. Nothing sorry, like I am just sharing of those. It will be this digital thing is very good, my lord. Digital thing is very good. My lord, kindly come to 2016 judgment, my lord. Jagdeep Singh, Punjab and Haryana High Court. The issue was same. Fact is of that whitewasher only. The paragraph 4, my lord, Roman 2, the exceptions which they have given us in that notifications, my lord. Now, my lord, kindly come. Thus, exceptions we will read at para 10. In the state of Punjab versus Rafiq Masih, this court held that while it is not possible to postulate all situations of hardships, where payments have mistakenly been made by an employer, in the following situations, a recovery by the employer would be impermissible in law. My lord, the issue was for this, Roman 2 only. My concern is Roman 2, recovery from retired employees or employees who are due to retire within 1 year of the order of recovery. Now, para 11 says, my lord, the principle enunciated in the proposition Roman 2 above cannot apply to a situation such as in the present case. In the present case, the officer to whom the payment was made in the first instant was clearly placed on notice that any payment found to have been made in excess would be required to be refunded. The officer furnished an undertaking while opting for a revised pay scale. He is bound by the undertaking. Now, my lord, my case was under the 6th pay commission. In the 7th pay commission, my lord, any appointment is made, he has to give an undertaking in writing, and I have not given any undertaking. Then this impugned judgment of the High Court was quasi and satisfied. So therefore, my lord, the action by the state respondent in deducting 4,13,000 rupees from my area by this impugned order, equivalent to the case leave, but through this impugned order is not sustainable. And because of, my lord, this dispute only, my pension paper has not been processed after my superannuation, my lord. And yesterday, my lord, I was arguing a pension matter, my lord, again. The gentleman passed away yesterday itself. He was not given pension by the government for 4 years. These kind of situations, my lord, we entangle sometimes. Now, my lord, that kind of 2025 judgment.
No, if Rafiq Masih's case covers your case, then why
My lord, but still, I will just indicate a paragraph, my lord. This is very important. This latest judgment, my lord. It was rendered on April 4, my lord. Para 9, my lord, I indicate, my lord. My brother Tapin is not having that judgment. Therefore, I was, for his convenience, I was trying to read it out so that he make it clear in his argument, my lord. Well, just 2 paragraphs, I close. This court has consistently taken the view that if the excess amount was not paid on account of any misrepresentation or fraud on the part of the employee, Here there is no misrepresentation nor fraud on my part of the employer, or if such excess payment was made by the employer by applying a wrong principle calculating the pay allowances, or on basis of particular interpretation of rule stroke order, which is subsequently found to be erroneous, such excess payment of emoluments or allowances are not recoverable. It is held that such relief against the recovery is not because of any right of the employee, but in equity, exercising judicial discretion to provide relief to the employee from the hardship that will be caused if the recovery is ordered. Now, I read this last paragraph below. Para 11. All the principles, letter judgment, which my brother Tapin would also be relying on, these are all reiterated in this judgment, my lord. My lord will kindly come. The same thing has been reiterated at 27B, B, A and B, my lord, is very clear. Then 28. 29, my lord, is same. Those judgments are covered. So therefore, my respectful submission is this, my lord, this impugn order, my lord, impugn order at page 24, my lord, is liable to be interfered with by this honorable court. There is already an interim order. The authorities that I have cited is on the pinpoint, my lord, subject to the contradictions by my brother Tapin on the government side. But hopefully I have demonstrated everything from his affidavit only, my lord. That is one aspect, my lord. Then in the next case, my lord, only the direction which I will not argue. In the next case, 387, my lord, because of this dispute, my lord, pension paper of the petitioner has not been processed, my lord. Only for a direction on this, my lord.
Lordship, I will start from the affidavit in oppositions filed on behalf of 2 and 4 in 386, Lordship. 386. Lordship, so far account examination is concerned, Lordship, which is mandatory for Lordship an employee, Lordship, in the promotional post, Lord, that is A and E, Lordship. If Lordship turn to page 44, Lordship. Page 44. As per the notification, Lordship, CPW manual, Lordship, where Lordship account examination is mandatory, Lordship, that is being followed. And this is the extract of that, Lordship, CPW manual, Lordship. Lordship, kindly turn to page, Lordship, 47, Lordship. Departmental examination for assistant engineers and executive engineers, Lordship. Lordship, fine, Lordship. Here, Lordship, arrangement has to be done by the Director General of Works, Lordship. Since this is CPW manual, Lordship, we have adopted, in our case, Lordship, Chief Engineer is the Lordship authority, Lordship, in a place of Lordship. Then kindly come to next page, Lordship. I'm taking Lordship to the relevant part only, Lordship. 48, Lordship. Notice the Lordship. Every executive engineer and assistant engineer includes shall have passed the departmental examination irrespective of age and length of service, Lordship.
Okay, note.
Note, Lord. And then kindly come to note 4, Lordship. The engineer officer promoted from one grade to another will not be allowed to draw increment in scale of the pay of the post to which they are promoted until they have passed the departmental exam prescribed for the grades which so and so is promoted. This is the Lordship, the extract of the CPW manual, which is being Lordship followed by every step. Then kindly come to page 50, Lordship. Page 50, Lordship. This is the notifications 19 July 2000. 19 July 2000. And petitioner was promoted on 22nd June 2001, Lordship. After this notification, Lordship.
No. This is not correct. I was promoted on 3rd October 2000.
3rd
October 2010.
3rd October 2000.
2010.
Even then, Lordship, it comes after this notification only, Lordship. This is of 19 July 2000. As my friend has clarified that, Lordship, he has been promoted in the month of October. Lordship.
This is for assistant engineer and
No.
No, not executive engineer is exempted from here. Please see.
Here for Lordship, therefore I took Lordship to the CPW manual, Lordship, the extract Lordship, where it's mandatory Lordship.
Fine, fine.
Here the omission, that part EE is not there, Lordship, but this particular which provision has been referred.
Even then, Mr. Tapine, that's
Lord.
all right. Even if we agree to your argument,
Lordship.
then how can you overcome the decision of the Supreme Court in Rafiq Masih's case?
Rafiq Masih case, Lordship, is, I'm coming to that also.
Hmm.
May I come to the Rafiq Masih case, Lordship?
Hmm.
What Rafiq Masih case, I'll come to the Rafiq Masih case itself, Lordship. Exactly what law has been laid down in this Rafiq Masih case, Lordship? It has been summarized, Lordship. Lordship can gather it from the paragraph 3, 4, and 6 and 7, Lordship. I'll come there, Lordship.
Facts are there.
May, Lordship.
Correct.
Because one of the Supreme Court said, in some cases, Lordship, it has been held, Lordship, if there's no fault on the part of the employee in fixations of the pay or anything by which the financial benefit has been taken, which he is not supposed to, Lordship. If there's no any fault on the employee, in that case, Lordship, it is what Honorable Supreme Court has held in this Rafiq Masih case and subsequent cases also, Lordship. That cannot be the law. If there's no fault on your part, it doesn't mean that Lordship, you have to enjoy the benefit. One judgment which has been, Lordship, just now my learned friend has placed. The JD Singh's case, Lordship, they are also so-called fixation of the pay scale is not on the part of the employee, Lordship. But he has given undertaking, Lordship. Therefore, Honorable Supreme Court dismissed the, Lordship, petition, Lordship. JD's case, Lordship. The fixation pay scale is not on the part of the, Lordship, the employee, Lordship.
Judicial officer. Even judicial
He has given the undertaking, Lordship.
I have not given.
What I'm trying to point out is, Lordship, that is not the settled law, Lordship. I'll satisfy it from this very Rafiq Masih case, Lordship. May I read, Lordship, the paragraph 3, Lordship? We need to
That
understand.
decision is not available before this court now.
Rafiq Masih case, Lordship. I have given the citation also, Lordship. Okay. Thank you. I have given the citation also.
Anyway, this is my lord. I have in my.
Before Rafiq Masih case, this particular case, Lordship, even the reference was made to the 3 benches, Lordship, court, Lordship. And after that, Lordship, it was remanded back. That reference is not required. Thereafter, this judgment has been passed. Then, kindly see the paragraph 3, Lordship. The issue that we have been required to adjudicate is whether all the private respondents against whom an order of recovery of the excess amount has been made should be exempted in law from the reimbursement of the same to the employer. For applicability of the instant order and the conclusion recorded by us hereinafter, the ingredients depicted in the foregoing 2 paragraphs are essentially indispensable. Merely on the account of the fact that the release of this monetary benefit was based on a mistaken belief at the hands of the employer, and further, because of the employees had no role in the determinations of the employer, could it be legally feasible for the private respondent to assert that they should be exempted from refunding the excess amount received by them? Insofar as the above issue is concerned, it is necessary to keep in mind that the following reference was made by the division bench of 2 judges of this court for consideration by the larger bench. In view of the apparent difference of views expressed on the one hand in Syam Babu Burma versus Union of India and Sahib Ram versus State of Haryana. And on the other hand, in Chandi Prasad Unial versus State of Uttarakhand, we are of the view that the remaining special leave petition should be placed before a bench of 3 judges. The registry is accordingly directed to place it. So and so by this other lawsuit, it has been referred to the 3-bench lawsuit. Now kindly come to the paragraph 5 lawsuit. The aforesaid reference was answered by the division bench of 3 judges on so and so. While disposing of the reference, the 3 judges division bench recorded the following observation in paragraph 6, Rafiq Masi. That's also Rafiq Masi lawsuit, on which reference was made lawsuit. In our considered view, the objection made by the court not to recover the excess amount paid to the appellant therein were in exercise of its extraordinary power under Article 142 of the Constitution of India, which vests the power in this court to pass the equitable orders in the hands of justice lawsuit. 142 is the power of the Honorable Supreme Court. On the base of the equity lawsuit, that power. Then kindly, having recorded in the objection so and so, reference answer so and so. Therefore, in our opinion, the decisions of the court based on a different scale of Article 136 and Article 142 of the Constitution of India cannot be based where upon the same grounds of reasoning. And thus, in view of the aforesaid discussion, there is no conflict in the views expressed in the first 2 judgments and the later judgment. That in that view of the above, we are of the consideration opinion that the reference was unnecessary. Therefore, without answering the reference, we send back the matters to the division bench for their appropriate disposal. Now, lawsuit kindly come to paragraph 6 lawsuit. In view of the conclusion extracted herein above, it will be our endeavor to lay down the parameters of the fact situations wherein employees who are beneficiaries of wrongful monetary gains at the hands of the employer may not be compelled to refund the same. In our considered view, the instant benefit cannot extend to an employee merely on account of the fact that he is not an accessory to the mistake committed by the employer, or merely because the employee did not furnish any factually incorrect information on the basis whereof the employer committed the mistake of paying the employee more than what was rightfully due to him, or for that matter, merely because excessive payment was made to the employee in absence of any fraud or misrepresentations at the behest of the employee loss. Having examined a number of judgments rendered by this court, we are of the view that the order passed by the employer seeking recovery of monetary benefits wrongly extended to the employee can only be interfered with in cases where such recovery would result in hardship of a nature which would far outweigh the equitable balance of employer's right to recover. In other words, interference would be called for only in such cases where it would be iniquitous to recover the payment made. In so far to ascertain the parameters of the above consideration and the test to be applied, reference needs to be made to situations when this court exempted employees from such recovery, even in exercise of jurisdiction under Article 142 of the Constitution of India. Repeated exercise of such power for doing complete justice in any case would establish that recovery being effected as iniquitous and therefore arbitrary, and accordingly the interference at the hands of this court lawsuit. Here lawsuit, Rafiq Masi case lies in these 2 paragraph only lawsuit, judgment lawsuit. Paragraph 6 and 7 is the what proposition has been lodged by the Rafiq Masi case lawsuit. Here lawsuit, as I have submitted lawsuit, because there is no fault on the part of the employee, that cannot be the law lawsuit. But if recovery is lawsuit, asked for lawsuit, it's going to cause any kind of hardship or not. In Rafiq Masi,
Is it his case that no hardship is caused to him even after retirement?
lawsuit, Rafiq Masi case lawsuit, here lawsuit, they are from the lawsuit category of the group C lawsuit, group C.
Maybe,
Here, Lordship, he is assistant engineer, Lordship. Sorry, superintendent engineer, Lordship.
Actually, it may be different, but the proposition of law laid down therein, whether it would not be applicable in case of the petitioner.
Lordship, to my understanding, Lordship, here recovery is sought for only 4 lakhs, Lordship. It's not going to cause any kind of hardship to the petitioner, Lordship.
Any
And
kind
one-
of hardship,
And one more
you are
thing,
deducting rupees 4 lakhs from the.
no, one more thing is there,
Person.
Lordship. One more thing is there, Lordship. It is not the case, Lordship, the petitioner was not aware, Lordship. In his representation, Lordship, he stated, Lordship, although his examination is required to be passed by me, but for this and that reason, it could not be happen. Therefore, exemption may be granted. That is the prayer made by the petitioner before the authority, Lordship. What I'm trying to point out from that very letter, Lordship, the petitioner knew that he was supposed to pass the examination. But even then, Lordship, he kept silence, Lordship. This very action is, Lordship, not acceptable. And for that reason, Lordship, the case of the petitioner is not, Lordship, comes under this category, Lordship.
So.
If Rafik Masi case is, Lordship, accepted as a law, what Lordship is understood and what my friend has submitted, Lordship, then Jaideep Singh's case, Lordship, which has been placed, Lordship, that would have been, Lordship, allowed by the Honorable Supreme Court, Lordship. Honorable Supreme Court
Difference is undertaking. Mine is not undertaking.
undertaking cannot, Lordship, discard the law laid down by the Honorable Supreme Court. If they, at all that is the law.
Come to 25. I have given 16. I have given.
Here, Lordship, this judgment has been already placed before this Honorable Court, Lordship. Here, Lordship, after retirement, Lordship, this recovery was ordered. In this case also. Since undertaking was given by that employee, that much prior, Lordship, when he joined, Lordship, that in future, if anything, then I'll, Lordship, refer, Lordship. Then accordingly, Honorable Supreme Court said, no, you have to. Its order has been given in the last paragraph, Lordship. It has to be returned in
In the present case, the petitioner has not given any undertaking.
Now, what I'm trying to point out is, Lordship, because there's no power on the part of the petitioner, Lordship, employee. That's not the law, Lordship. Suppose say in this case also, giving undertaking, if at all this is the judgment of proposition and law laid down by Honorable Supreme Court, Lordship, if excess payment is made, that cannot be recovered. If that is the law, Lordship, giving undertaking or not, it will not, Lordship, discard that law. That's my point, Lordship. What I'm trying to point is, Lordship, it depends on the case to case, Lordship. In the present case also, Lordship, it's not that, Lordship, he was not aware that this account examination has to be passed, Lordship. He was aware, Lordship. Nowhere he says it, Lordship, I was not aware. He was aware that knowing fully, Lordship, he had not given the examination and he has not passed, and even after that, Lordship, he kept drawing the salary in the Lordship, enhanced post, Lordship.
No, he has been perhaps given the payslip, and payslip is issued by the AG office.
Correct.
Lordship,
And on the strength of that payslip issued by the AG, he has drawn the amount.
Lordship, that part is always there, Lordship. That part, because
Then-
what is law is the Lordship, because you cannot have the Lordship fruit out of the wrongful actions of any other person, Lordship. This is also a principle, Lordship. which principle has been discarded by the Honorable Supreme Court, it will depend on the case-to-case basis, Lordship. And one more judgment, that's of 2025, Lordship. Here also, Lordship, this is regarding the, I have already, Yogeshwar Sahu. Yogeshwar Sahu also, Lordship.
Mine is para 9 and 11.
Here also it says, Lordship, just read. The appellants having supernated on a material post of stenographer were admittedly not holding any gazetted post as such, Lordship. Here also, Lordship, since Rafiq Masi case is on the background that they were from the Lordship category of C and D, Lordship. So here he is from gazetted, Lordship, post, Lordship, this in present case, Lordship. So therefore, Lordship, hardship is the Lordship, the main Lordship factor which has to be kept behind the Lordship decision, Lordship, whether hardship is going to be posed or not. Apart from that, Lordship.
No, merely because he was superintending engineer, no hardship is caused to him. Is it the proposition?
So that is being supported by the Lordship. What I am submitted is, Lordship, he knew that, Lordship, this examination has to be passed, Lordship. He knew, Lordship. Nowhere he said that I was not aware. If knowing fully, Lordship, I allow something to happen, Lordship, in my benefit, then that be permitted, Lordship, and out of that you will have the benefits. This is my point.
That's all right, but when he failed to appear in the examination, you could have stopped the increment there. Then the matter would have ended there.
But that
After
action,
the retirement now.
that action of not doing that, Lordship, is not correct. And that wrong action, out of that wrong action, one cannot have the benefits. That's what I'm pointing out. And that is also
No, Mr. Tapin, like 142, Article 142, the Supreme Court has exercised equitable jurisdiction.
equitable.
Similarly, this under Article 226 also, the court exercises equitable jurisdiction.
Lordship, when Lordship, equitable jurisdiction, Lordship, what's equitable? Equitable must be based on some kind of facts, Lordship, supporting facts, Lordship. Supporting facts, suppose a SE is being superannuated, a recovery is of 20 lakhs, Lordship, 10 lakhs, Lordship. So it's sound, so if it's recovered, then how he'll sustain his life. This call, Lordship, the equity, when equity comes, Lordship, equity is just to balance the hardness of the law only, Lordship. Honorable Supreme Court does it. What judgment has been passed by Rafiq Masi and some other case? There's not the law, but there's equity only. That's based on the equity law. Here, Lordship, 4 lakhs is being, Lordship, being ordered for recovery, Lordship. So whether one thing is he knew that the examination was supposed to be passed, which he did not, Lordship, because of again, Lordship, the thing he keep drawing the salary, Lordship.
Yes, what is the latest judgment you were referring to?
Lordship, this is
Yogeshwar Sahu, my lord. I have
already placed.
My case will be covered by paragraph 9 and 11. And I don't know which paragraph will be in favor of my brother Tapin.
Paragraph number 9.
Mine is
Yes,
9.
you have referred it.
Para 9 and 11.
Which I refer is last paragraph. That's paragraph 11, Lordship.
Paragraph 11.
11.
Okay.
Here only the gazetted, he is not that he is from the gazetted post, Lordship. Therefore, it has been allowed, Lordship. But in present case, he is from gazetted. Hardship is, Lordship, decided on the basing on some certain facts, Lordship.
District judge. This man is the district judge.
District judge.
So gazetted question does not come. He is also, in fact, district judge salary is higher than the chief superintending engineer.
No. He is from stenographer. He is stenographer in this case. No district judge. Jadid's case is
I stand corrected, brother, with my brother Tapin, because that impugn order was passed by the district judge Cuttack.
And this Jadid Singh's case, Lordship, here, Lordship, Honorable Supreme Court recovery has been ordered in installment in 2 years, Lordship, where the employee is the Lordship, the petitioner is the district judge, Lordship. The Honorable Court directed to recover. And one last judgment I would like to place, Lordship, that is Chandi Prasad Unial's, which year? They are the panelist. 2012. That is
referred in this all the.
Yes.
These are referred, Miller.
Referred.
These are referred, not required. Indicate the paragraph, but still you want referred. These are quoted in all the letter judgment, Miller. These are quoted.
Here also, Lordship, the petitioners, they were teachers, Lordship, principal, holding the post of principal or teacher, Lordship. Here, the Honorable Supreme Court allowed recovery. Here, Lordship, if paragraph 13 onwards, Lordship, we are not convinced that this court in various judgments referred to herein before has laid down any propositions of law that only if the state or its official is established that there was no misrepresentation or fraud on the part of the recipients of the excess pay, then only the amount paid could be recovered. On the other hand, most of the cases referred to herein before turn on the peculiar facts and circumstances of those cases, either because the recipients had retired or were on the verge of retirement or were occupying lower posts in the administrative hierarchy. We are concerned with the excess payment of the public money, which is
Well, just time is up. Just we can indicate the paragraph.
Paragraph number?
Paragraph 13, 14, 16 laws. 13, 14, 15, 16 laws. Can you note that 8 also laws. 8 also laws. And this is also Rafiq Masi also two judge bench laws. And here also laws 2 laws. And it was prior to Rafiq Masi case. And Rafiq Masi case, as I pointed out, paragraph 6 and 7.
You do one thing, you indicate the same in a plain paper. Yes, we will. Oh, what are the paragraphs you have relied upon?
Here, Lordship, 8, 13. No. I'll indicate and
only one 10-second rejoinder is, my lord, I am fully protected by page number 52 of the affidavit in opposition filed by respondent number 2 and 4, my lord. Here, page 50, my lord, page 50. Annexure B, 19 July 2000, my lord. This was only in context of the AE and the junior engineer, my lord.
And one more is
Annexure? It was annexure.
Annexure B, my lord, page 50. This covers me because this was only in respect of junior engineer and the assistant engineer, but the executive engineer, SC chief engineer was not brought under the purview of the CPWD manual. Even if the CPWD manual is there, unless it is not notified by the state government, it will not.
CPWD is was adopted long time back. It's already applicable.
No, that proposition is not correct, brother Tapin. Be fair.
And one more thing, Lordship. Regarding this Tagong Ketan's page 101, which my friend has referred, Lordship. This is in case of Tagong Ketan, Lordship. This here, Lordship, the case is different. Case is different. This is which has been referred here is of RWD. Here RWD Sec 11/2000. This is with effect from 10/8/2001. But in present case of 2000, because notification is of 2000. So therefore, this is not correct.
My lord, will see this. My brother Tapin is trying to misplace the argument. I'll read for you. Well, this notification, 19 July 2000, just I finish it. Pursuant to adoption of norms and procedure of CPWD manuals by all works department under the government of Arunachal Pradesh, the departmental examination in respect of assistant engineers, engineers in the Department of Public Health Engineering and Water Supply is hereby enforced. As per provision of CPWD Manual Volume 1 in toto, and in the same line of procedure adopted in AP Civil, AP PWD for conducting such departmental examination for release of increment. Consequent upon the issue of this order, the effects of departmental examination on henceforth in respect of AEs and Js will be regulated under provisions of para 13, which he has quoted. If my brother Tapin says there is if the executive engineer is included, I surrender.
No.
I'll move out.
Then
I have no case.
no. I'm reading.
No, you cannot go beyond this.
What I'm reading.
You cannot go beyond this.
I'm reading.
And all his summation, my lord, is not
No.
in consonance with the record.
Lordship, kindly see
No.
the last part, Lordship. This order will come into force with immediate effect, Lordship.
Immediate effect date of 19.
This is 19 July
2000.
2000, Lordship. 19 July 2000.
Executive engineer is not there.
19 July.
That's all,
2000.
my lord.
And what this letter is referring is with effect from.
You
10
cannot travel
October
beyond the
2001.
record. Nothing
Therefore,
else.
I'm clarifying this one.
No. That's how you can go beyond the record.
This is immediate effect from 2000. And this letter, which my friend is annexed in the affidavit reply, it talks about the with effect from 10 August 2001 also. So therefore, I'm just correcting this, Lordship. This is
No, I am saying that
Annexure
executive
3, 101.
engineer is exempted from the purview of departmental examination.
in present case,
Right.
notification is of 2000, Lordship. The example, the document annexed by my friend is of which is effect from 10/8/2001, Lordship.
1 year after. 1 year after.
So
my
therefore,
promotion.
Lordship, this case is different.
No, 1 year
what-
after my
what's-
promotion,
what
my
I'm
lord, this
going
was
to
issued.
bring out.
1 year after. Because I was promoted as an executive engineer on 3rd October 2000. And this notification come into effect in 2001, after 1 year.
No. Where is that notification?
My promotion.
No. Show me. Rather, my friend is diluting the things by annexing this
Nothing.
document, Lordship.
Nothing, my lord.
Where is these notifications of 2001, Lordship? Where's the document here?
This is your documents, Tapin.
Where is the document?
This
you,
is.
you
this
have
is-
annexed.
This is your.
No, you
RTI
have
report.
annexed in your affidavit
Your
reply.
File noting, my lord. All the arguments, my lord. No,
No.
I'm respectfully disagreeing
I'm
with
just
him.
correcting the
No,
text laws.
Please let us not travel beyond the records. That's all. Grateful, my lord.
I'll urge Mr. T.T. Tadal, learned counsel for the petitioner, and Mr. Tapin, as the respondent, argument concluded. Judgment is.
This is yours, Tapin. I don't require. All letters, no? Okay, go ahead. Given the books. Maybe the lordships.
Yes.
No, yesterday, my lord, I had given
Lord, I have made submission on two aspects, Lord. Main was that the entire process of reference was initiated on two counts. And yesterday I had dealt with that no locus standi of the person who has made the reference on the strength of a power of attorney. And the second submission was that it is only when the landowners refuse to accept the compensation or they protest, and then only they can go for such reference, which was missing. Now, my lord, today my third limb of argument is that it is all initiated by fraud. Any judgment or decree obtained by court by practicing fraud on the court is vitiated, and fraud vitiates all solemn acts and all transactions.
That's all. What is the second argument? Second line of argument?
Second line of argument was that in terms of the provisions of LARR Act, it is only when the landowners are aggrieved and they make protest for the compensation or anything, so they have to lodge it, and thereafter only they can do it, which is completely missing in the present case.
Yes.
And today I will first clarify that this all transaction of making a reference is perpetrated with fraud, and it has been a fraud with the court as well as the government belongs. That after having received the compensation, after having signed the settlement deed, one person, he not only acting as a power of attorney holder, meaning thereby an agent of the landowners, but on his own account also, he makes a reference application. Now that makes a lot of difference, my lord. Now, my lord, a person can either be acting for his own or acting as an agent of another. My lord. Now, here is a case where this person is acting for his own interest also, and he is purported to be acting on the interest of others as an agent, as their agent and power of attorney. Yesterday I had clarified that his entire action of making himself as an agent is perpetrated with fraud. Now, therefore, my lord, today I will further be, I am developing my argument that his action not only suffers from no locus standi, that he has not no locus, his action also suffers from fraud, and fraud vitiates everything. So his entire action of moving to the court and then bringing on record the power of attorney, and that is only on the strength of power of attorney, vitiates the entire thing and the judgment, and it becomes, my lord, a nullity from very beginning. So the entire judgment is a nullity in the eyes of law. Now, my lords, for that purpose, my lord, we have given a list of books, my lord, on the issue, my lords. Now, my lords, firstly, I will be making my submission on the issue that when a person goes on the strength of a power of attorney, then whether he can go along with his interest as well as interest of the others. He can't go, my lord. A constitution bench of the Supreme Court has held that. Now, for this purpose, my lord, I am relying on few judgments, my lord. Oh, books have come? Achha, it's coming. All right. Then before that, my lord, I will be making other submissions, and then I will come on the judgment, my lords. Now, my lords, so far as the
power of attorney was concerned, now these are all my issues which goes directly to the root of jurisdiction. And if the root goes, then everything will go. Then the subsequent point which has been, my lord, without properly deciding the question of jurisdiction, whether at the instance of, क्या नाम था उसका? Nico Bassi. Dudley Riba, the reference itself at all was maintainable or not. Now, if it is not maintainable, then none of the landowner has come to the court. Therefore, and my lord, the Dudley Riba also, now if your lordship will see the impugned judgment at page 59, reference application. Now, if your lordship will see, instead of impugned judgment, the reference application, my lord, this is at page 170. I'm sorry, just unpinned petition. Reference application. My lord, the reference application is at page 170.
Okay.
Annexure 2, my lords. Now, if your lordship will see. Now, if your lordship will have pleasure to see this reference case, lordship got my lord page 170. Now your lordship will see here. Now, my lord, the person, Mr. Dudley Riba, he has not filed this reference in his own name for himself. Now, he has filed it. Now, if your lordship will see the first, it is Sri T. Migo Basar. And then, my lord, other persons, Gomi Bam, Seni Riba, Migo Bam, 5 Monia Bam, Marli Bam, Mokem Ban, and then others, my lords. And so far as his name is concerned, where is this? My lord, along with this, his name is at serial number 33. Sorry, this is Dudley Bam. Now, so far, Dudley Riba is concerned. 79.7. At serial number 79. Dudley Riba. So, my lord, and if your lordship will see at page 90, page 188, page 188, my lords. The total number of persons are 102. Now, my lord, this 102 includes Sri Dudley Riba also. That your lordship will find at page 188. And here at the last, it is mentioned. Now, my lord, all are represented by their duly constituted and appointed power of attorney holders, namely Sri Dudley Riba. Now, my lord, this list also includes his name. Now, whether he is also, my lord, represented by our constituted attorney. This is the reference application filed before the reference court, my lords. Now, then, if your lordship will kindly come to page 190. Again, here your lordship will find in paragraph 2, my lords, page my lord 190, that the applicants are represented by their duly constituted attorney Sri Dagli Riba, who is duly empowered to act for and on their behalf in the matter relating to acquisition of their land and claims for compensation. And my lords, here it is mentioned that copy of the power of attorney of the applicant landowners in favor of Sri Dagli Riba is annexed. Now, the continuing fraud also continues in the court when he, in the cause title, he includes his name, and after the end, at the end of the names, he mentions that all are being represented through the constituted power of attorney, including his name. Now, there is no separate, my lord, after that, there is no separate appeal reference on his behalf, on his own behalf. Whereas he has said that his also land is there of 50 acres in this acquisition. So, my lords, he has also interest in that. So either he is acting in his capacity as a person, in his personal capacity as a landowner, or he is acting in the capacity as a power of attorney holder with respect to other landowners.
So he has also received the compensation amount.
Yes.
And without protest?
Everything. Yes, my lord. Yeah, I have shown to your lordship yesterday his own signature at every place, my lord. Original also in March and November also. When, my lord, after the award, they came 21/11, my lord, they came and received, and through check they received. He is also one of them. And in his deposition also, he says that my land is also there of 50 acres. And even he did not make any protest, my lord. My lord, there is absolutely no whisper of protest or disagreement, my lord. Absolutely missing completely. Now, at this juncture, kitab nikalo. Books come. Any books. Mari books. There. No. Now, my lord, if your lordship will see the LARR Act. LARR. Please. 77 record. Now, my lord, section 64. 77.
64.
64, your lordships. My lord, this is the provision with respect to reference to the authority, my lord. If now, my lords, who can make the reference? Now, it starts with the word reference to authority, 1, subsection 1. Any person interested who has not accepted the award. So, my lord, any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the authority, as the case may be, whether his objection be to the measurement of land, comma, the amount of compensation. Now we are concerned with the amount of compensation, nothing else. The person to whom it is payable, the right of rehabilitation, etc. My lord. We are not concerned with this, my lord. And then, my lord, the provider, the collector shall within period of 30 days, etc. My lord. Now, my lords, your lordship will see there is a last proviso here. Provided further that the collector may entertain an application after the expiry of the said period within a further period of 1 year, if it is satisfied that there was sufficient cause for not filing it within the period specified in the first proviso. Now, kindly come to section 77. Number of section 77 talks about payment of compensation or deposit of the same in authority. Now, my lord, this is with respect to circumstance when the payment cannot be made to the person concerned, then it has to be deposited with the authority. Now, your lordship will see here. It is subsection 1. On making an award under section 30, the collector shall tender payment of compensation awarded by him to the persons entrusted entitled thereto according to the award, and shall pay it to them by depositing the amount in their bank accounts unless prevented by someone or more of the contingencies mentioned in subsection 2. Then will not kindly come to subsection 2. If the person entitled to compensation shall not consent to receive it, or if there be no person competent to alienate the land, or if there be any dispute as to title to receive the compensation, or as to the apportionment of it, the collector shall deposit the amount of compensation in the authority to which a reference under section 64 would be submitted. Now, my lord, what is very important here? Provided that any person admitted to be interested may receive such payment under protest as to the sufficiency of the amount. So there is a specific provision by way of proviso in section 77 that if any person is aggrieved by the amount of compensation, then he may receive the payment under protest. Now, my lord, this is very important. The next proviso. Provided further that no person who has received the amount otherwise than under protest shall be entitled to make any application under subsection 1 of section 64. So, it becomes a prerequisite for a person to make a reference that he must receive the amount under protest. Now, this objection was also specifically taken before the authority meets. That in the present case, therefore it is directly and intricately connected with the power of attorney. That who are the persons who have made the reference? Whether all the landowners actually who had absolutely lodged no protest at any stage, whether they or somebody else is acting and trying to create the mischief on their account and trying to get the benefit out of it. And therefore, yesterday I had used the word, it is trading in litigation. That in the name of litigation, you are doing some mischief. Now, my lord, in view of these two provisions, now they had to come forward in the court. Now, my lord, surprisingly, in the entire proceeding, right from inception of the application for reference and till date, none of the landowner has come. It is only that Dagli Riba, everything is being done by him. Now, my lord, he and the notary public got a power of attorney prepared, and on the strength of that power of attorney, he filed a reference, he maintained reference, he deposed in the court. None of the landowners came in the court, nor they were called in the court, even to support the power of attorney, whether they have actually given, or actually they could have been questioned whether they have made a protest or not. Have they protested? And the learned trial court, my lord, presumes everything. And based on that, he proceeded and delivered the judgment. And only based on that, absolutely no evidence. Lord, that reference court is a trial court. Its, my lord, judgment is a decree of the civil court. Okay. Now, my lords. Your lordship will find that now there are two provisions of. No, take that. I would like to show to my lords. Power of attorney. Both have. Now, my lords, the claim is based on power of attorney, my lord. Now, my lord, power of attorney is governed by Power of Attorney Act. Not in fact, my lords. My lord, this act has been made. In fact, this was an enabling act, my lord, for those people who were unable to perform certain acts or certain transactions because of various reasons, my lord. So they could appoint an agent who can be their power of attorney to perform anything on their behalf. It's a solemn act, and the instrument is to be created by the donor. Now, my lord, if your lordship will see, there are certain provisions of this power of attorney. Lord, 1A, it is this act. Power of attorney includes any instrument empowering a specified person to act for and in the name of the person executing it. In this act, power of attorney includes any instrument empowering a specified person to act for and in the name of the person executing it. So the person who is executing it, now the person in whose favor it is executed, now becomes entitled to do everything or whatever act he has been authorized to perform, he can perform on behalf of the person who is executing the power of attorney. Then, my lords, kindly see 2. The donee of a power of attorney may, if he thinks fit, execute or do any instrument or thing in his own name and signature and his own seal, where sealing is required by the authority of the donor of the power, and every instrument and thing so executed and done shall be effectual in law as if it has been executed or done by the donee of the power in the name and with the signature and seal of the donor thereof. This section applies to power of attorney created by instruments executed either before or after this act has come into force. Now, my lords,
whether any particular mode is prescribed here for execution of the power of attorney in this act?
So for this act is concerned, no, because this is a very small act of section up to section 5 only, because nothing, no rule has been prescribed. So it becomes more important that it must be genuine. Otherwise, anybody can create a power of attorney and say that I am his attorney holder and he can register a land also or his property also. So therefore, the court has to be very, very cautious when a power of attorney holder comes on behalf of some principal to be assured that actually this is a power of attorney executed by the owner, because it gives right to the person. It is also like special power of attorney is also like a wakalatnama executed in favor of an advocate, my lords, to act on his behalf. And recently, my lords, now this has been happening nowadays, it's fraud and misuse have started happening very frequently. We have bought, my lord, 2 judgments of Supreme Court. We have bought recent 2 judgments of the Supreme Court, where on the strength of wakalatnama is nothing but for power of attorney. Now, my lord, lawyers are given wakalatnama by the client. It is nothing but an authority to appear, because lawyers are skilled persons, qualified persons having license to practice. So they can appear before the court on the strength of the wakalatnama, and serious fraud, cases of fraud has come to the court, my lord. That I will be dealing with later. So, my lords, power of attorney, execution of power of attorney does not prescribe anymore. Therefore, it becomes more important when a matter goes in the court and where it is subjected to any challenge or relating to some property. Now, my lord, here the learned judge said simply that it is nothing. It is not a transfer of property. It is only for pursuing his case for compensation. It becomes more important. The judge was required to be more cautious that the person who is supposedly executed the power of attorney, he ought to have been summoned to come in the court in view of the objection specifically raised as a preliminary objection in the proceeding, that the person is claiming to be the power of attorney holder has got no locus because the power of attorney is bad in law. But he did not do so. Now, my lords, kindly come to Notaries Act. Notaries Act. Lord, I'll just read it. It's also a very small act, minor act. Yes. Now, my lord, this is also very sacrosanct act, my lord, and solemn act. Now, if your lordship will kindly come to section 8, functions of notaries, because prior to that, it is the appointment, etc. of notary public. Now, my lord, if your lordship will have pleasure to see section 8, functions. A notary may do all or any of the following acts by virtue of his office, namely. A. This is very important, my lord. Verify, authenticate, certify, or at least or attest the execution of any instrument. He can verify, authenticate, certify, or attest the execution of any instrument. Now, my lord, we are concerned with this because rest are with respect to promissory note, etc., bill of exchange, noting and protesting, etc. Then, my lord, E is important. E is to administer oath or to take affidavit from any person. Then, my lord, G, prepare, attest, or authenticate any instrument intended to take effect in any country or place outside India in such form and language as may conform to the law of the place where such deed is intended to operate. Then translate and verify the translation or any document from the language of another. Act as a commissioner to record evidence in any civil or criminal trial if so directed by the court or authority. Act as an arbitrator and any other act which may be specified. Now, no act is specified in subsection 1 shall be deemed to be a notarial act except when it is done by a notary under his signature and official seal. Now, my lords, your lordship have seen here the first A, verify, authenticate, certify, or attest the execution of any instrument. Now, my lords, here is a case where, now my lords, so far as Notaries Act is concerned, here rules have also been made about the notary. Now, my lords, if your lordship will come to Rule 11, your lordship will find a notary in transacting the business under the Act shall use the form set forth in the appendix to these rules. Besides recording declaration of payment for owner, a notary shall also register noting and protest made. Every notary shall maintain a notarial register in the prescribed form 15. Where any demand of acceptance or payment or better security has been made by a clerk, notary shall, after examination of the entry in the register relating to such demand, affix his signature thereto and cause the clerk to affix his signature also to the entry. Each notary shall, before bringing the notarial register into use, add a certificate on the title page specifying the number of pages it contains. Such certificate shall be signed and dated by the notary. Then every notary shall permit the district judge or such officers as the appropriate government from time to time appoints in this behalf to inspect his register at such times, not oftener than twice a year, as a district judge or officer may fix. District judge or officers appointed by the appropriate government will have the power to lodge a report to the appropriate government for taking action against a notary. When the original instrument is in language other than English, any noting or protest or entry in his register which has to be made in respect of the instrument by a notary may be made either in the language or in English. Now, my lords, note and certify the general transactions relating to negotiable instrument, prepare a will or other testamentary document, and prepare and take affidavits of various purposes for his notarial act. Every notary shall grant a receipt for the fees charged and realized by him and maintain a register showing all the fees and charges realized. Then seal. Every notary shall use a plain circular seal of a diameter of 5 centimeters as indicated by drawing given below, bearing his name and name of the area within which he has been appointed to exercise his functions, the registration number and circumspection notary, and the name of the government which appointed him. Then, my lords, this is with regard to the conduct of notary. Inquiry into the allegation of professional or other misconduct of the notary. Now, therefore, my lords have seen from the main provision, section 8, that he has to authenticate, certify, or attest the execution of any instrument. So, my lord, whenever a notary has to certify or attest or authenticate an instrument, then the person must be before him, and the person is to be identified that he is the same person. Otherwise, there cannot be any occasion for the notary to authenticate any instrument. Now, these are the provisions in relation to the notary as well as power of attorney, my lords. Now, my lords, on the basis of power of attorney, my lord, the judgment is, first judgment I would rely, lordship will be, Lord, it is Janki, Vasudev, Bhojwani and other versus IndusInd Bank and others. that is reported in 2005 to SCC 217. Now, my lords, if your lordship will kindly come to one second.
Yes, paragraph number.
Lordships, paragraph number 13 first. Can you speak? Now, my lords, it says, Order 3, Rule 1 and 2 CPC empower the holder of power of attorney to act on behalf of the principal. In our view, the word acts employed in Order 3, Rule 1 and 2 CPC confines only to in respect of acts done by the power of attorney holder in exercise of power granted by the instrument. The term acts would not include deposing in place and instead of principal. In other words, if the power of attorney holder has rendered some act in pursuance of power of attorney, he may depose for the principal. He may depose for the principal in respect of such acts, but he cannot depose for the principal for the act done by the principal and not done by him. Similarly, he cannot depose for the principal in respect of the matter of which only principal can have the personal knowledge and in respect of which the principal is entitled to be cross-examined. May I read it again, my lords? So that can be properly appreciated, because this is a very important aspect of the matter, my lord. Now, my lord, I am reading it again. The term act would not include deposing in place and instead of principal. In other words, if the power of attorney holder has rendered some act in pursuance of power of attorney, he may depose for the principal in respect of such act. But he cannot depose for the principal for the act done by the principal and not by him. Similarly, he cannot depose for the principal in respect of the matter of which only the principal can have the personal knowledge and in respect of which the principal is entitled to be cross-examined. My lord, I am just connecting the fact by example, my lord, that like in the present case, whether any particular landowner, because out of 102, if one or two, any landowner, whether he received the compensation because it is a personal act on protest or not, now he could have only deposed in the court, not the power of attorney holder, because this is a matter of personal knowledge. And power of attorney holder is not doing any act with respect to this, accepting the payment or protesting as a power of attorney holder. ठीक है. ये जज का है.
Yes.
Lordships. No, my lord. Then paragraph 14, having regard to the directions in the order of remand by which this court placed the burden of proving on the appellants that they have a share in the property it was obligatory on the part of the appellants to have entered the box and discharged the burden. Entered the box and discharged the burden. They should have come in the court to discharge the burden. Instead, they allowed Mr. Bhojwani to represent them, and the tribunal erred in allowing the power of attorney holder to enter the box and depose instead of the appellants. Thus, the appellants have failed to establish that they have any independent source of income, and they had contributed to for the purchase of property from their own independent income. We accordingly hold that the tribunal has erred in holding that they have a share and are co-owners of the property in question. The finding recorded by the tribunal in this respect is set aside. Now, my lord, then apart from what has been stated, this court in the case of Vidyadhar versus Manik Rao observed at SCC page 583, 584, para 17 that where a party to the suit does not appear in the witness box and state his own case on oath and does not offer himself to be cross-examined by other side, would arise that the case set up by him is not correct. So far as these aspects were concerned, that whether the compensation was paid to them to their satisfaction, or they were aggrieved, or they had made the protest, or they did not participate in the survey, or they did not sign in the assessment sheet, were all the facts of personal knowledge. Because power of attorney has been claimed to be executed later on. So all these facts were required to be proved by them by deposing in the court, which has not been done. Now your lordship will see that in civil dispute, the conduct of parties is material. The appellants have not approached the court with clean hands. From the conduct of parties, it is apparent that it was a ploy to salvage the property from sale in the execution of decree. Now, my lords, para 17. On the question of power of attorney, the high courts have divergent views. In the case of Sambudhat Sastri versus State of Rajasthan, it was held that a general power of attorney holder can appear, plead and act on behalf of the party, but he cannot become a witness on himself on behalf of the party. He can only appear in his own capacity. No one can delegate the power to appear in the witness box on behalf of himself. To appear in a witness box is altogether a different act. A general power of attorney holder cannot be allowed to appear as a witness on behalf of the plaintiff in the capacity of the plaintiff. Now, my lord, here is a case of a special power of attorney, where the power is also, even the alleged power is restricted with respect to certain lands. The aforesaid judgment was quoted with approval in the case of Ram Prasad versus Hari Narayan, para 18 minutes. It was held that the word acts used in Rule 2 of Order 3 CPC does not include the act of power of attorney holder to appear as a witness on behalf of a party. Power of attorney holder of a party can appear only as a witness in his personal capacity, and whatever knowledge he has about the case, he can state on oath, but he cannot appear as a witness on behalf of the party in the capacity of that party. If plaintiff is unable to appear in the court, a commission for recording his evidence may be issued under the relevant provision of CPC. In the case of Pradeep Mohan Bey, Doctor versus Minguel Carlos Dias, the Goa bench of the Bombay High Court held that a power of attorney can file a complaint under section 138, but cannot depose on behalf of the complainant. He can only appear as a witness. However, in a case of so-and-so, on which reliance has been placed by the tribunal, in the present case, the High Court took a dissenting view and held that the provisions contained in Order 3 Rule 2 CPC cannot be construed to disentitle the power of attorney holder to depose on behalf of his principal. The High Court further held that the word act appearing in Order 3 Rule 2 takes within its sweep depose. We are unable to agree with the view taken by the Bombay High Court in Florindo Amarindo. We hold that the view taken by Rajasthan High Court in the case of Sambhudat Sastri, followed and reiterated in the case of Ram Prasad, is a correct view. The view taken in the case of Floriano Armando Luis cannot be said to have laid down the correct law and is accordingly overruled. In view of this, that we have taken in the view that we have taken, we hold that the appellants have failed to discharge the burden that they have contributed towards the purchase of property at 38 Koregaon Park, Pune, from any independent source of income, and failed to prove that they were co-owners of the property at 38 Koregaon Park, Pune. This being the core question on this score alone, the appeal is liable to be dismissed. My lord, these are the relevant law laid down with respect to, my lord, the scope of power of attorney. Now, my lord, in the present case, the power of attorney holder is the only one who has deposed in the case. Neither the landowners have come to support with respect to the fact which was within their personal knowledge, as all those facts happened prior to the execution of power of attorney. That too, fraudulent power of attorney, I say. And therefore, there is absolutely no relevance of the deposition of this power of attorney holder. Not for the present, my lord, I would like to place his deposition, my lord, in this context.
It's part of the record?
My lord, it must be part of the record.
In the record.
It's in the record. The reference court record is here.
Page number?
Lordship. ठीक है, liquid text पे कहाँ है? निकालो. Lordship will have it, my lord. Because I don't have the page number in the lower court record, so I have the certified copy.
There was no paper book prepared,
Lord,
my lord.
these are the all depositions, my lord. PW1. He is Sri Dagli Riba, age 35 years, son of late Marpak Riba, village Deepa, Lower Siang district, taken on oath on solemn affirmation under provisions of the Indian Oath Act before me on 23rd September 2024. Kindly see. It is a fact. All the beneficiaries are my acquaintance and 10, 12 are my relatives. Now, my lord, thereafter it is very important. I have above 50 acres of land. Now, my lord, the question arises that in the present reference my lords have seen, I have shown to my lords that the reference application has been filed. Now, it is not in his name. It is claiming to be on the basis of the power of attorney. Now, and I have above 50 acres of land. He is claiming in person of his own. The power of attorney was executed on 9/11/23. Now, my lord, your lordship will see this date. Now, after this date, he has signed, and all the landowners have signed their agreement, my lord, at the time of receiving the compensation. Now, my lord, 102 executants of power of attorney. Now, my lord, the question arises here also, my lord, when a person commits a fraud, then he commits repeated mistakes. Now, this 102 includes him also. Lordship has seen the list just now, my lords. How can he be his own power of attorney? He cannot be. A person cannot be power of attorney of his own. Either he can appear or he can do any act in his own capacity, or as an agent of other, or power of attorney of other. Now, my lord, we as an advocate In some cases, we appear in person. Then we remove our gown and band, my lord, and we appear in person. But when on the strength of Wakalatnama, we are representing a client, then we have no personal interest in the list. Now, my lords, the power of attorney was executed on 9/11/23 at Likabali. 102 executants. Here, this 102 includes him also. So this is also a fraud. Executants of, and this is being said on oath, I'm sorry to say. 102 executants of power of attorney came from different places and assembled in the office of notary. All the beneficiaries are my relatives. Hence, now, my lord, there he says that all the beneficiaries are my acquaintance. And here he says, all the beneficiaries are my relatives. Hence, I took up this responsibility. But it is to be clarified that some of the beneficiaries are acquaintances and distant relatives, and some are close relatives. It is a fact that 102 executants put their signature in my presence. Where were the witnesses? Because you are the beneficiary of the power of attorney, if at all you are. So, how can you be the witness? There has to be independent witnesses. Now, Toko patta, bamboo, orange banana, and other forest timbers were grown in the acquired land. It is not a fact that I took the signature of all beneficiaries at their respective residence. It is not a fact that the executants did not subscribe their signature and thumb impression in the power of attorney. I know the award was approved on 13/11/13. It is a fact that we did not protest the acquisition. Now, my lord, kindly see. It is a fact that we did not protest the acquisition of land, but we wrote a letter to the DC on the rate of compensation. No letter written by him has been brought on record. Now, if at all any letter would have been written by him on record as a power of attorney, that would have come on record. No. I have written the application to the DC about 10 days after receiving the compensation. It is a fact that we were not satisfied with the compensation after receiving 100% of the award amount. Then, my lord, how did he sign on the acceptance letter? If this is a fact, then. We were not aware of signing any deed of acceptance. But we signed on a paper containing our name with photo. He appears to be, my lord, a literate person. Now, my lord, I'm putting a question to myself. Can it be believable that a person will be signing before the deputy commissioner without knowing the contents, what for his signatures is being obtained? We signed on a paper. So, all this is admitted, my lord, containing our name with photograph. This is not disputed. I got the idea of reference case of Sri Yomi district relating to acquisition of land by the defense in higher rate. It is not a fact that reference case was not filed as per law. It is not a fact that we are not entitled to get enhanced rate of compensation because we have signed in the deed of acceptance as we dispute to have signed the deed of acceptance. Where is the dispute? I'm putting a question to myself. Absolutely no dispute. We did not challenge the notification issued by government of Arunachal Pradesh in 2022, popularly known as Land Acquisition Manual. You have a copy of the manual?
Yes.
Lords, I'm putting a question to myself here, in view of this. The position that it is not a fact that we are not entitled to get enhanced rate of compensation because we have signed in the deed of acceptance as we dispute to have signed on the deed of acceptance. Now, my lords, here, when he is making certain claim that about dispute, then it was the onus was on him to prove it. But no evidence has been led to that effect. Absolutely no evidence. So that onus was not discharged. Then, my lord, it is not a fact that we have been paid the appropriate compensation as per government notification. I cannot say how much I am entitled to get compensation, but it could be decided by the court. It is not correct that I cannot compare the rate of sale deed annexed in my petition because it is all small land and acquired land is a big land. Now then, my lords, another very important aspect in his cross-examination. It is correct that I have no record that the willingness certificate was obtained under fraud. So, my lord, it is his admission that the willingness certificate was obtained from all the landowners. Him also. He cannot certify it about landowners because willingness certificate was signed by the landowners in March. So at best, for him, he is accepting and admitting that.
No. The purport and meaning of this sentence is quite different as you.
Sorry, my lord.
As you perceive. The purport and meaning of this line is quite different.
No, my lord. What he says is, it is correct.
He admitted that he had no record of the willingness certificate.
No, my lord. He
Was
has
obtained
no
under
record
fraud.
that, yes, that the willingness certificate was obtained by fraud. Now, my lord, he claims that the willingness certificate was obtained by fraud.
This is
or
an
not obtained.
admission. Admission on his part that he has no willingness, no record to show
Yes.
that willingness certificate was obtained under
Yes,
fraud.
meaning thereby the willingness certificate has been obtained and he has no record that it is obtained by fraud. So it has been obtained. So he admits that willingness certificate has been obtained, and for disputing that or challenging that, he has no record. That he admits here. Now, it is a fact that willingness certificate was signed on 19/3/20. So he admits this, that willingness certificate was signed, and he can depose about himself. Now he says, but only few people signed it. Then again, it is contrary to record. But I have shown yesterday to your lordship that each and every landowner signed on the willingness certificate, which was duly witnessed by the village level chairman and village level secretary, and also by the DC in presence of a witness. So this part is also accepted by him. Now it can only be about himself, he himself, not for others. Others has not come. And it cannot be said that he has any personal knowledge of others. Now he says only few people signed it, whereas the record says that each and every one has signed it. So again, if he tries to dispute it, it was he who had to prove this fact in the court, which he did not do. So there is an admission on his part that it was signed by him on 19/3, and it was not by way of fraud, because he said that I have no record. Now, my lords, I have no idea regarding quantum of compensation unless received of the final award. It is not a fact that we have filed this case on greed, but we have filed this case to claim our rights. He had all idea because everything was mentioned in the document which he has signed and he admits to be signed, and which he does not dispute it. He admits it. Then, my lords, it is a fact that the land was, again he admits, my lord, it is a fact that the land was properly surveyed and assessed by the Deputy Commissioner. Again, his admission binding on him. I do not know how many hydro projects and other projects were established between the Basar to Deporizo. I do not know whether the acquired land is under GRS. Then, Lord's, next page. I came to know about the rate fixation by notification dated 6/9/2022 after receiving the award. Now, my lord, he is pleading his ignorance. All the documents he have signed containing the rate. And he says that only when the award was passed, then I could come to know. Blatantly false on the face, contrary to record. It is a fact that till receiving of 80% of the compensation. Now, my lord, then he says, it is a fact that till receiving the 80% of compensation, I was not aware of it. Now, my lord, if he was not aware of it, then what for? He had supplied his bank account to the authorities, his Aadhaar card to the authorities, then only the 80% compensation was deposited in his bank account. I was not aware of it. It is a fact that sale deed documents enclosed in my petition to determine the market value was not submitted before DC. Then Leprada, during the process of land acquisition. Then I clarify that the facts that all the beneficiaries are acquainted with me and some of them are my relatives, and it is not a fact that all beneficiaries are my relatives. Again, my lord, he is changing his version. 3 times he has changed his version here. These are his evidence. So, my lord, he has only deposed in the court, none else. And just now, your lordship have seen from the judgment of the Supreme Court, then that so far as the matter of personal knowledge is concerned, even if a person who is validly appointed as a notary public, as a power of attorney, he can only depose about his knowledge, about the knowledge of the fact which has happened with him and the executed, and not on behalf of others, or which has been in the personal knowledge of others. He can't depose for that. Then, my lords, क्या चीज दूसरा जजमेंट क्या था ये? हाँ. Now, my lords, at page 256, my lords, now, my lord, just now he said that I sent a letter. Now, if your lordship will kindly come to page 256.
Yes.
Now, my lord, this is a letter dated 28/9/23. Now, your lordship will see to the Deputy Commissioner, and this is signed by Sri Tommy Baum, not by the Dudley Reba, my lords. He says that I have written a letter. Just now, your lordship have seen in his deposition. Whereas this letter dated 28/9/23 is written by a single person. And not except this, none has written any letter. And this has been received in the office of the Deputy Commissioner, because the seal is there. And he writes, my lord, and this is 28/9/23, my lords. And after this letter, the award has come and acceptance deed has been signed by them, including this. Tommy Baum has also signed and accepted and received the award and the entire compensation. Now, he says the undersigned has come to know that a notice under section 21 has been issued by this office with respect to acquisition of land at Prem. However, a copy of the same has not seen in the notice board of this office, neither the copies of the same has been served to the undersigned in any manner. In this regard, being a bona fide landowner whose land is the subject matter of acquisition, the undersigned would like to state that category of land as classified for acquisition and the market value as sought to be awarded is erroneous and the lower side. The said value does not reflect the true nature and price of the acquired land, is as high as rupees 10,000 per square meter, even on the minimum side. The valuation is required to be done by comparable sale data under section 26, and set aside should be therefore be carried out before making the final award. It is also stated that even before issuance of section 21 notice, provision of section 40 of the Act was implemented, thereby preventing the landowners from raising objection to the acquisition so far as the market value is concerned. It is thus requested to assess the actual market value, and thereafter the necessary multiplication factor, solicium and interest could be added to the award as required under law by carrying out, if necessary, hearing and determination under section 23, expecting your kind cooperation, necessary action, and his name and signature. Now, my lord, it is not by Dagli Divan, and which he has stated. It's by one person, and thereafter that person was felt aggrieved when the compensation was received by him. And he has received also the compensation.
This letter was prior to receiving of the compensation.
Yes, this letter was prior to receiving of the compensation. And after receiving the compensation, none has been. Admitted position is none were remained aggrieved. Then, my lords, another, my lord, important judgment on power of attorney, that is a constitution bench judgment, my lords. Sorry, this is Allahabad High Court judgment, my lord. Of course, full bench judgment of Allahabad High Court, presided by Justice D.Y. Chandrachud. My lord, paragraph 15. Copy iska diya hai kya? Citation is 2016 SCC online. Allahabad. Paragraph
15.
My lord, the Supreme Court judgment which I referred to, my lords, my lord.
Yes.
Based on that only. Now, my lord, your lordship will find Order 3 of CPC provides for recognized agents and pleaders. My lord, sorry, para 15, my lord. 14, 15. Para 15, my lord. Now, my lord, rather I will read from paragraph 14 itself.
Okay.
Order 3 of CPC provides for recognized agents and pleaders. Rule 1 provides that any appearance, application, or act in or to any court required or authorized by law to be made or done by a party in such court may, except where otherwise expressly provided by any law for the time in force, be made or done by the party in person, or by his recognized agent, or by a pleader appearing, applying, or acting as the case may be on his behalf under Rule 2 of Order 3. Recognized agents of the parties by whom such appearances, applications, and act may be done or made include persons holding power of attorney, authorizing him to make and do such appearances, applications, and act on behalf of such parties. Hence, it is evident from the provisions of Order 3, Rule 1 of the CPC that an appearance or act in or in any court which is required to be made or done by a party in a court, in the court can be effectively made or done by the party in person or by recognized agent. A recognized agent for that purpose includes a person who holds the power of attorney. This is a specific application, as if it were of provisions contained in Section 1A and 2 of the Power of Attorney Act 1882. These provisions would indicate that there is no prohibition on an application seeking a writ under Article 226 and 227 of the Constitution being pursued by a litigant through the holder of a power of attorney. The donee of a power of attorney is no more than an agent of the donor. Now, this is very important. The donee of a power of attorney is no more an agent of the donor. The donee represents the donor and does not pursue the proceeding in his own independent capacity. He acts for and on behalf of the donor and is subject to the limitations which are contained in the instrument by which he is authorized to act on behalf of the donor. The donee acts for and on behalf of the donor in the name of the donor and not for himself. Lord, I am emphasizing on this. He is acting on behalf of the donor and not for himself. He can't act for himself. His persona is as an agent of the donor and is subject to limitation created by the deed by which he is authorized. Then, my lords, we skip few more paragraphs and come to paragraph 24. My lords.
Yes.
My lords, when a writ petition under Article 226 of the Constitution is instituted through a power of attorney holder, the holder of power of attorney does not espouse a right or claim personal to him, but acts as an agent of the donor of the instrument. The petition which is instituted is always instituted in the name of the principal. Now, my lord, this is very important. It is instituted in the name of the principal who is the donor of the power of attorney and through whom the donee acts as his agent. Now, my lord, in the present case, your lordship have just seen that it is in the name of not Dagli Riba, but in the name of T. Migo Basar Mills. So it is purportedly claimed to be of a person of whom Sri Dagli Riba is projecting himself as a power of attorney holder. And not in his personal capacity, but as an authorized agent. But, my lord, in the reference you have seen, among the list of 102, his name also appears. And in his evidence, he has said that my acres land are also there. So everything is mixed here. In acting in his personal capacity also, and acting also as a power of attorney. Now, my lords, then, my lord, paragraph 25. Lord, having held so, we must at the same time emphasize the necessity of observing adequate safeguard where a writ petition is filed through the holder of power of attorney. These safeguards should necessarily include the following. The power of attorney by which the donor authorizes the donee must be brought on record and must be filed together with the petition application. The affidavit which is executed by the holder of a power of attorney must contain a statement that the donor is alive and specify the reason for the inability of the donor to remain present before the court to swear the affidavit. The donee must be confined to those acts which he is authorized by the power of attorney to discharge. This is the law laid down by a full bench of Allahabad High Court. I say law recognized by that a power of attorney holder must be acting on behalf of the donee and not for himself. Now, my lord, then my third limb of argument. Lord, I was making my submission, Lord, with respect to the locus of a person who is claiming to a power of attorney, and that also that locus also on the basis of the fact that no protest has come from any of the landowner, either before the authorities or before the reference court. None of them has come to depose. It was their reference, therefore they had to prove their case. Not even the power of attorney has been come to be proved, nor any fact about the dispute that they were disputing or they were aggrieved by that. So none of them can be said to have been an aggrieved party in terms of section 64, read with section 77 proviso, to be entitled to make a reference. And they could not prove it. None of them could depose in the court to prove it. Now, my lord, on the proposition that fraud vitiates everything, lords. Who reference court को deal करेंगे? Now, my lord, now, my lord, so far as the judgment that fraud vitiates everything that is reported in Milord 2007 4 SCC 221. 2007 4 SCC 221 AV Papaya Shastri and others versus Government of Andhra Pradesh. Huh? Now, my lord, straight away, I invite my lords to paragraph 21 minutes of this judgment. My lords got it, my lord? Not. Now it is well settled principle of law that if any judgment or order is obtained by fraud, it cannot said to be a judgment or order in law. Before 3 centuries, Chief Justice Edward Coke proclaimed, fraud avoids all judicial acts, ecclesiastical or temporal. Para 22. It is thus settled provision of law that a judgment, decree or order obtained by playing fraud on the court, tribunal or authority is a nullity and non-est in the eyes of law. Such judgment, decree or order by the first court or by the final court has to be treated as nullity by every court, superior or inferior. It can be challenged in any court, in any time, at any time, in appeal, revision, writ, or even in collateral proceedings. In the leading case, in Lazarus Estates Limited versus Besley, Lord Denning observed, no judgment of a court, no order of a minister can be allowed to stand if it has been obtained by fraud. In Dukes versus Christone, Smith leading case, 13th edition, explaining the nature of fraud, D. Gray CJ stated that though a judgment would be res judicata and not impeachable from within, it might be impeachable from without. In other words, though it is not permissible to show that the court was mistaken, it might be shown that it was misled. There is an essential distinction between mistake and tricky. The clear implication of distinction is that an action to set aside a judgment cannot be brought on the ground that it has been decided wrongly, namely on the merits. The decision was one which should not have been rendered, but it can be set aside if the court was imposed upon or tricked into giving the judgment. That was, court was misled or tricked. Trick was played with the court. That itself is a fraud. Now, it has been said, fraud and justice never dwell together. Fros it jus nonquam cohabitant, or fraud and deceit ought to benefit none. Fraud may be defined as an act, deliberate deception with the aim of benefit by taking undue advantage of another. In fraud, one gains at loss of another. Even most solemn proceedings stand vitiated if they are actuated by fraud. Fraud is thus an extrinsic collateral act which vitiates all judicial acts, whether in rem or in personam. The principle of finality of litigation cannot be stretched to the extent of an absurdity that it can be utilized as an engine of operation by dishonest and fraudulent litigants. In SP, Chengalvaraya Naidu versus Jagannath,
Not necessary to multiply the decision, or the proposition of law is well settled.
Milords, I'm not multiplying.
Yes, everything.
Milord, these 2 paragraphs are very important. Therefore, I'm reading.
No, this is not a paragraph, but it is a quotation simply.
Your Lordships. Therefore, Milord, there has certain relevance. Otherwise, I would not say. Lord says, this court had an occasion to consider the doctrine of fraud and the effect thereof on the judgment obtained by a client. In that case, 1A by registered deed relinquished all his rights in the suit property in favor of C, who sold the property to B. Without disclosing that fact, A filed a suit for possession against B and obtained preliminary degree. During the pendency of an application for final degree, B came to know about the fact of release deed by A in favor of C. He therefore contended that the degree was obtained by playing fraud on the court and was a nullity. The trial court upheld the contention and dismissed the application. The High Court, however, set aside the order of trial court, observing that there is no legal duty cast upon the, now my lord, this is very important. There is no legal duty cast upon plaintiff to come to court with a true case and prove it by true evidence. Now, my lord, this is what the High Court had said, that it is not a duty on a plaintiff to come with a true case and prove it by true evidence. Justice, we approach this court, now, my lord, then, my lord, allowing the appeal, setting aside the judgment of the High Court and describing the observations of the High Court as wholly perverse, Kuldeep Singh J. in para 5. The court of law are meant for imparting justice between the parties. One who comes to the court must come with clean hands. We are constrained to say that more often than not, process of court is being abused. Property grabbers, tax evaders, bank loan dodgers, and other unscrupulous persons from all walk of life find the court process a convenient lever to retain the legal gain indefinitely. We have no hesitation to say that a person whose case is based on falsehood has no right to approach the court. He can be summarily thrown out at any stage of litigation. Lord, this is what I wanted to read here, because Lord, I am going to, Lord, they are going to take this plea that this man, Dagli Riba, who is claimed to be the power of attorney holder, he is not doing for his own. What is the ground? The ground is they have taken that the money will be going in the account of those persons, not in my account. Now, the person who can play fraud and who can prepare a false power of attorney of a dead person and others, then he can do anything. He can open a bank account in the name of one person and the money can be driven. He can manage anything. So, my lord, the court has said that one must come to the court with clean hands. Irrespective whether he is going to gain or not is something different. But the person must be a bona fide person approaching the court. Then, my lord, two more paragraphs, my lord. These are also citations, my lord, of another judgment, so I will not multiply that. But the principle which lordships have held, my lord, that fraud vitiates everything, and those who practice fraud and come to the court, now, if he does not come with a clean hand, then everything is vitiated and it becomes void ab initio, that is nullity from very inception. Now, my lords, so, my lord, on this preliminary issue about the jurisdiction, Lord, presently, my lord, I am not going on other aspects about multiplication. That is on merits of the case, my lord. Multiplication factor and rate, etc., my lord. Because it is a matter where at the very threshold, this ought to have been seen by the learned trial court, which it failed to do it. So, my lord, to that extent, my lord, it is completely bad in law. Now, your lordship, I will take your lordships to the award, my lords. Award. My lord, or rather, the judgment of the trial court, the reference court. Now, my lord, the impugned judgment. Now, if your lordship will kindly come to the impugned judgment, the pagination is, it starts from page 60, my lord. It is there, my lord. Is it there, my lord? Sorry, page 59.
Yes, yes.
Lordships. Now, my lords, your lordship will find it. Now, my lord, I skipped the case of the parties, my lord. So if your lordship so permits me, my lord. Should I place the case of the parties here or
Not necessary.
I should come on the issues, my lord?
Yes.
Lordships. Now, my lord, the issues have been framed by the court at page, my lord. My lord, 78. Now, my lord, 78, my lord. The very first issue is the instant reference suit is maintainable in the present form or not. Whether the reference proceeding was initiated on protest by the beneficiaries as referred under the law. Whether the applicant petitioner is entitled for multiplication factor. Whether the applicant petitioner is entitled, whether the notification dated 6/9 was correct or followed by the respondent number 1. Whether the market value of rupees 150 is justified, whether the landowners are entitled to get award or solicium, whether the landowners are entitled to cost. Then, my lords, it is mentioned that the petitioners and the respondents, number 1, examined one witness each. However, the respondent number 2 to 5 adduced evidence of 3 witnesses as DW2, DW3. The PW1 exhibited as many as 19 documents to rely upon, which are the marked as exhibit 1 to 19. Then DW exhibited 14 documents and marked them. Then respondent number 6 has not, my lord, made any deposed need. Now, my lord, your lordship will kindly come to my lord, we made a specific objection to the my lord, page 74, my lord. The very maintainability, my lord, before coming to the issue, my lords, case of respondent number 2 to 5, my lord. Page 74. Lordship got it, my lord?
Yes.
Lordship. Now, my lords, the respondent number 2 to 5 objected the suit, raising the maintainability of suit and also the correctness of power of attorney holder. So, at the very threshold, we had raised this issue. The compensation amount was disbursed on 21/11/23 on acceptance of the landowner without protest, and as such, there is no cause of action to bring this suit. It is also objected that it is not known who filed the application to the respondent number 1 for reference. Whether it was filed by the petitioners or PA holder, and the copy of the application for reference is not furnished to them. The respondents did not get the copy of the statements made under section 65 of the Act by the respondent number 1. Apart from the technical objections, so my lord, the court is treating these to be technical objections. The respondent number 2 to 5 does not have disputed the documents, but they are mostly relied on government of Arunachal Pradesh notification dated so and so as the base rate of fixation. The acquired land and petitioners did not object the rate according to 80% of the estimated compensation was paid under section 40 of the Act before taking possession of the land, and 20% was paid later on. The petitioners have executed the willing, now this is important. The petitioners have executed the willingness and no change of mind certificate that no asset will be claimed by them in future. The classification of rate was determined after extensive joint survey. These are all admitted facts. The established procedure was duly followed and the compensation was adequately paid to the petitioners. It is also pleaded that the market value under section 26 could not be done in the state of Arunachal Pradesh as the state is non-cadastral where no sale data is available. Hence, the state government fixed the market value of different states in Land Manual Act, and the same is the final. As per the said manual, the petitioner is only entitled to have multiplication factor on 1, and the Land Manual Act being fixed by the government is binding on all the parties. The petitioners are not entitled to any interest. Look, I leave it here because that objection I wanted to show this, my lord, that at the very threshold, we took objection on these two counts, my lord, about that the power of attorney holder had no authority to make a claim. Now, my lords, and no protest. Then, my lords, kindly come to the relevant issue, my lord, at where it has been dealt with. 1B, it is 1B, my lord. At page 89, the issue 1 has been bifurcated into 3 issues. Page 89. And my lord, there, if your lordship will see 1A, whether the instant references suit under 64 is filed within limitation period or not. Lord, we are not much concerned about this because that was not the issue which was raised, but this was framed by the learned court below of itself. Then, my lords, kindly come to 91. 1B. Now, if your lordship will see 1B, whether the suit instituted by power of attorney holder is valid or not. Now, my lord, this is the most important, which because it goes to the root of the matter and goes to the jurisdiction and make it nullity. 48th paragraph. The respondent number 2 to place it, my lord. The respondent number 2 to 5 has questioned the power of attorney of the petitioners, Exhibit 1, in their written statement by raising the issue of Indian Registration Act 1908 and more particularly the provisions of section 32 and 33 of the Registration Act. It has been contended that it is not known as to whether the same was voluntarily executed. Now, this is very important. Same was voluntarily executed by the ex-landowners. It is not known that whether the executors are still alive. So even that was also raised there. But by that time, my lord, the death certificate was not available. Now, the power of attorney holder is the beneficiaries and ex-owners of the land, and thereby there is a conflict of interest. The power of attorney holder is the beneficiaries and ex-owner of the land, and thereby there is a conflict of interest, and he cannot represent other landowners as referring the citations referred above. Lord, I have just now shown those judgments. On the other hand, learned counsel for the petitioner have submitted that the third party who is not a party to the execution cannot raise the issue. The matter of executors being alive or dead is also only a vague point. Now, my lord, I emphasize here, my lord, because when we raise this issue in our appeal, that a power of attorney is purported to have been executed by a dead person, then here an affidavit has been filed by the Dudley Riba. He has affirmed the oath, my lord, and here he says that the lawyer has prepared that power of attorney, and by mistake he has seen the name of all the owners of the land from the award published. So he has by mistake mentioned that. So it is not that the individual landowners have come and executed the power of attorney and he has typed the name from the award. That is what he has taken here. And here he is saying, so far as the executors being alive or dead is a vague point. If the respondents want to establish the fact that executors are not alive, the burden of proof lies on them to prove the same. Very unfortunate. I'm sorry to say. Now, my lord, whether the power of attorney was executed by the power of attorney holder or not, once this issue was raised before the court, the onus was on them to prove, to call the owners of the land to in support of that they have executed the power of it. And with respect to whether any person is dead or alive or not, that could have been proved by them that no, we are very much alive, we are here, we have executed the power of attorney in favor for convenience. None. So everything is done by this. Every affidavit is filed by him, everything is done by him. And that has been accepted as a gospel truth by the learned flag. The issue of mismatch, now specifically it was raised that in the so-called power of attorney, in our written statement, even the numbers, serial numbers were mentioned that there is a mismatch of signature. The signature is not genuine of these persons. A specific instance. Now I'm putting a question to myself. When this question is raised, now whether a person has signed or not, it is within his personal knowledge. Can other side prove this fact? Other side can raise the issue that apparently there is a mismatch from the record. Now they had to come and prove it. No, this is my signature. Or the issue of mismatch of signatures in the power of attorney, as alleged, is also not relevant. The judge says it is not relevant. As on close scrutiny, it is seen that such minor difference may crop up in writings of the landowners who are mostly horticulturists. So they are horticulturists, therefore mismatch. But when in the assessment sheet in March, they have signed it with their signature and photographs, and in the acceptance deed, they have signed it with their photographs, that is not believed by the judge. And here it is said that there can be, because they are all horticulturists. Some signatures are long signatures and some are short, and that may happen over a period of time. Now, my lord, I'm sorry, this is a reference, inference drawn by the learned judge. More pertinently, the executors have not come forward to contest that they have not signed the power of attorney. Now, how could they know that their power of attorney is being used? We have raised it. So the court was under duty to call them. They should have been summoned. Unless they know that they have, on their behalf, a proceeding is going on. My lord, here I pause for a moment in lighter vein. My lord, recently, a case had come and it has been very widely reported in the legal social media platforms, that is Live Law and Bar and Bench. What happened in the Supreme Court, one SLP was filed, my lord, seeking quashing of a criminal proceeding. Now, in that SLP, notice was issued and a lawyer appeared through a wakalatnama and stated before the, my lord, kindly see the audacity of a person bringing a lawyer with a wakalatnama saying that he is the person, I am representing the complainant. And we have settled the matter. Compromise has taken place. And on the strength of that, the Supreme Court passed the final order. Now, after 2 to 3 months, somehow when the final order reached in its concerned area, High Court, and then from there to the concerned district court and area, then somehow somebody came to know about this. And thereafter, the person on whose behalf wakalatnama was filed, then they approached the Honorable Supreme Court. And there, when they approached the Honorable Supreme Court, then they filed an application. And then this fact could be exposed. Unless it is brought to the notice of the person, how can he know and how can he come to know? How can he come to approach the court? And here the court is saying that they did not come to this court. And how do they know it? Have you issued notice to them? They all their name figures. But you have not bothered to issue notice to them to come and support whether have you executed any such power of attorney which is being claimed by Mr. Dudley Reba that I am acting on the strength of the power of attorney. Absolutely nothing. So we not here. More potently, the executors have not come forward to contest that they have not signed the power of attorney. So we not somebody behind his back, by creating a false power of attorney, will sell the property, and then the court will say, no, 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 they have not come forward. Now, then what is said? Power of attorney is essentially a contract of agency, and such termination of agency can happen as per section 201 of the Indian Contract Act when the principal revokes the authority given. It is also replied that the relied judgment of the respondent number 2 to 5 are decided in writ petition cases. My lord, the judgment which I have shown to my lord of Allahabad High Court was relied upon there. Now, how it is brushed aside, that it was in the writ petition cases, the power of trial court to allow the power of attorney holder is permitted in order 3 of CP. Lord, I'm sorry. My lord, have just seen in paragraph 21, order 3 of CPC was referred by the full bench, and the judge is just throwing it. No, that was in the writ. In fact, my lord, in writ proceedings, it has been decided that even a writ under Article 226 and 227 can be pursued through power of attorney. That is the ratio of that judgment, and that is being just thrown. Now, my lord, upon perusal of Exhibit 1, that is the relevant power of attorney, executed on dated 9/11/23 on stamp paper, and the same is notarized. Now, my lord, the learned judge did not bother to see whether this notarization of power of attorney is valid or not, whether the notary public has signed it, whether any person, any lawyer was there to identify the executants, whether the witnesses have authenticated that, whether anybody has witnessed that, whether date mentioned as against on the date on which it is said to have been executed, where this has come, whether this creates a serious doubt this could have created to them. And he says ki notarize. The law relating to power of attorney in India is governed by the Power of Attorney Act, but the method of execution of power of attorney is not specific. So anything can be treated as a power of attorney. Section 17 of in this the documents for which registration is compulsory. It was not a case of that. It is a case whether it is fraud or not, whether the power of attorney is a bona fide and genuine power of attorney or it is a fraudulent document, whether it has been executed by them who are claiming, for whom the claim is being made that they have been executed by them, have actually executed it or not. Then, a power of attorney does not find mention in section 17 of the Registration Act, and hence, all these facts which was raised before the court has not at all been discussed, simply thrown out, and then Registration Act is being discussed. The same is not mandatory as per law, and the same therefore falls within the ambit of section 18 as a document of which registration is optional. Now, since the compulsory registration of power of attorney is not mandated by law, the question of registration is not a relevant factor. And then, my lord, section 32 and 33 of the Registration Act is part of the chapter 4 of the Registration Act, which is relating to manner of presenting a document for registration. As per section 32C, the document can be presented for registration by the power of attorney holder. Section 33 speaks about the power of attorney holder who can present the document for registration. Under section 32C, the stand of the respondents in this regard is erroneous, because section 32 and 33 of the Registration Act does not speak about registration of the power of attorney itself, but registration of documents presented by the power of attorney holder. For instance, when the power of attorney holder is empowered to sell a land and he presents the sale deed for registration, the provisions of section 32(3) are pressed into operation. In the present case, the attorney has been given only to the extent of pursuing judicial remedies to get compensation. The Exhibit 1 power of attorney does not extinguish any right of the executors, nor does the same convey any right over immovable property of the executors. The right over immovable property of the executor is already extinguished by the process of land acquisition, and they already stand divested for their title and ownership. Now, my lord, completely failed to consider that it is this power of attorney is being used for seeking, my lord, the consideration of that land, which had sought to be acquired. And therefore, the provision of section 32 and 33 was very much applicable in this case also. The claim made in this reference is only for determination of compensation. What is that? Lord, I'm putting a question to myself. Lord, that is nothing but consideration. Compensation is consideration for the value of land. In this regard, the DW1 was cross-examined by respondent number 2 to 5, and the DW1 has made a clear statement that no payment has been made to any power of attorney holder, and payments are made by bank transaction to the respective landowners. Now, my lord, whether this fact was required to be verified by the landowners or not, I'm putting a question to myself. Merely a person claiming to be the power of attorney is making the statement, and that is being believed as the gospel truth. Lord, then the whole proof, Lord, whole yardstick of proof of a case in a court will vanish. Everything can be deemed to be proved unless it is proved. When all these disputes are being raised in the court, it was duty of the court to prove it by evidence. And it was the duty of the plaintiff to prove it by evidence. But everything is presumed by the court. Made bank transaction. So this was a fact. So this fact was required to be proved by the plaintiff in the court, but it is being presumed that it might have been done or it must have been done. There is thus no legal or factual ground to question the power of attorney. Now, this is the reasoning. The power of attorney holder in terms of attorney is only acting in a fiduciary capacity and not just for his benefit. Now, whether they are acting in fiduciary capacity or not, well, it would have been proved by the holder of land, not this person who is claiming his right on the basis of the power of attorney to pursue in the court. He is also one of the landowner. Now, that made the case worst. And in that respect, he has represented other landowners in a joint effort to secure fair compensation of such individual. Now, my lord, this is completely in the teeth of the judgment or in the teeth of the law laid down by Honorable Supreme Court and Allahabad High Court full bench. The decision of the Allahabad High Court with regard to power of attorney as submitted by respondent number 2 to 5 do not apply to the present fact and circumstance of the case, as the said case is relating to a writ petition. You will see. And finding of the court ultimately recognizes that a writ petition under Article 226 can be filed by a power of attorney. The safeguards mentioned therein are also because the writ proceeding is a summary proceeding. Now, my lord, the learned trial court has also made this proceeding as a summary proceeding, my lord. No witness was summoned for proving. And the decided based on affidavits alone. Whereas reference proceeding is more akin to a civil court, and order 3.2a clearly permits attorney holder to institute the case. So, my lord, definitely it permits an attorney holder to institute a case. Absolutely correct. But then not to prove the case. The proof has to come from the evidence of the owners of the land, whether they have executed the power of attorney or not, and about all other facts which is only within their personal knowledge. As with respect to that part, attorney has not done anything. It is within their personal, whether they have signed or not, it is within their personal knowledge. They have accepted it not, they have received it in their bank account or not, exclusively personal knowledge. Now, and before the alleged date of power of attorney, if at all, even if the power of attorney is correct, held to be correct on 9th, then also, it was much before that. The argument of the respondents by referring to the word immovable property in the Indian Registration Act does not apply to power of attorney, as a power of attorney does not transfer any right, title, interest, and the said proposition is evident in the decision cited by the parties. Suraj Lamb, it has been held that a power of attorney is no difficulty, absolutely no dispute to this proposition. Suraj Lamb is well known, celebrated decision. And then, my lord, he has cited 3-4 cases about power of attorney, that there is an agent and principal relationship, but that has to be proved. When the very institution is under challenge, is under dispute, then para 55, the law recognizes a notarized power of attorney as being valid. Now, whether notarization is valid or not, once there is a valid execution and notarized, then only the law will recognize it. As per Section 85 of the Indian Evidence Act, the court shall presume, so it need not be proved, shall presume that every document purporting to be power of attorney has been executed before and authenticated by notary public or any court, judge, magistrate, India Council or representative of the central government was so executed or authenticated. The same provision contained in Section 84 of the Bharatiya Sakshya Adhiniyam. Very correct, Miller. But this is only when it is found to have been not in dispute, then it can be presumed. Not in the manner in which the learned court has applied this provision. Now, Lordship has seen here the word is used, authenticated by notary public. Now, my lord, I have shown to my lords that it cannot be said to have been authenticated by the notary public due to various reasons: mismatch in signature, mismatch in date, absence of witness, absence of identifier. How the learned court has gone into that? Then it was required to be proved whether it has been done, whether it has been executed by those who have actually, against whom it is claimed that they have executed it, and by the notary public also. The notary public also was required to be called in the dock to prove this fact. Or representative so and so, that it is also seen that the reference petition clearly bears the name and addresses of all landowners in the area of the petitioner, and the power of attorney holder has only signed the petition in their behalf. Now, my lord, so the court accepts that the power of attorney holder has only signed on their behalf. Lord, I'm putting a question to myself. What about himself? Now, his name also appears at the one place in 102 numbers of petitioners reference before the reference court, and also in the so-called power of attorney to be acting as a power of attorney holder. Now, in what capacity? I'm putting a question to myself, that was it not the duty of the court to see in what capacity this man, Delhi Riba, had approached the court? And in what capacity? Now, it is not a case, therefore, where the power of attorney holder has come forward as the loan petitioner in exclusion of the landowners. The power of attorney is only representing the petitioners as per the authority given to him in the power of attorney. Order 3, Rule 2A of the Code of Civil Procedure also recognizes the authority of a power of attorney holder to act and make application on behalf of the party. In view of the presumption, now, my lord, your lordship will see. So the learned judge has completely decided that no evidence is required, and I can presume. So he has come to the conclusion on presumption and not on any evidence. Completely perverse. In view of the presumption available under the law and the provision of the CPC, the Exhibit 1 power of attorney is therefore acknowledged to be duly executed, and thereby empowering the attorney holder to act on behalf of the landowner to pursue their claim of payment of just and fair acquisition compensation. Accordingly, the issue 1B is decided by holding that there is no legal impediment or infirmities to institute. So that is not on evidence, that is on presumption. Now, whether such presumption could have been made or not in these glaring facts of this case. Now, my lords, then your lordship will see the next issue. My lord, the issue is at the page 99, issue number 2 minutes. Because it is intricately connected, my lord, with the first issue. 19. Whether the reference proceeding was initiated on the protest of beneficiaries as referred under the law. Now, my lord, because these two issues are straight away, it goes to the root of jurisdiction. Now, whether reference at all has to be maintainable or not, are these two issues. Now, and both are directly based on facts. And the finding has to be recorded on facts. But the learned judge has, with respect to 1B, has gone on presumption and has accepted it. Now, whether the reference proceeding was initiated on the protest of beneficiaries as referred under the law. Now, not kindly see. The payment of land compensation took place through bank transfer. The compensation amount was transferred to the beneficiary's bank account without requirement of the physical presence of the petitioner. Thus, receiving of compensation with protest has to be understood from the context of what happened after the compensation was credited into the bank account of the landowners. Now, my lord, here I pause for a moment. Now, my lord, it appears that the learned trial court has taken a very microscopic view of the situation. Now, my lord, he has forgotten that this was a case under section 40, wherein 80% had to be paid after preliminary notification itself. And that was already paid in July, 80% of the compensation. And prior to that, there was an assessment sheet agreement which was signed by this willingness not to change their mind. All that was done. And then even for the purpose of taking of compensation, receiving the compensation in the bank account, now the learned judge has mentioned that since it has come in the bank account, so therefore there was no need of their physical presence. Now, my lord, there is a need of physical presence. Hand over their Aadhaar card, their bank account details, and if required, if Aadhaar is not there, their identity by way of either voter list or any other ID. So for that purpose, they had to approach to meet the authorities for this purpose, but completely overlooked. Then the word protest is not defined in the Land Acquisition Act. It is not specified whether such protest should be verbal or written. On the contrary, an application seeking reference is to be written application. Now, my lord, even if on the one hand is completely perverse finding that it is not written or oral. Now, my lord, even there must be some oral. Now, that has to be proved in the court by the landowners, because this fact, whether they have made a protest, is within their personal knowledge. Now, my lord, I'm putting a question, was it done? Not done. So here also, he says that it is verbal or written. So if it is verbal, then it has to be proved in the court that it was a verbal protest. Now then he says the application seeking reference is to be a written application. Then, my lord, these words in section 64 and 77 was redundant, superfluous. It has no meaning. While the respondent argued that no protest was made, the petitioners advance a case that seeking reference within 6 weeks from the date of award is itself a protest. So, my lord, filing a reference application, like, my lord, in the CPC for, my lord, recovery of money or many other things, my lord, notice under section 80 is required to be sent. Now, my lord, if a person files a suit for recovery of money without notice, unless and until that is waived by the order of the court, the suit will not be maintained. Now, here it is a specific provision, statutory provision. Now that mandates, there is a legislative mandate that all those who have accepted it cannot maintain. So these specific requirement of law could not have been brushed aside by the court by saying that reference, so, my lord, then any person can file a suit. Now, my lord, recently, my lord, there is a, my lord, Commercial Court Act, my lord. Now, in the Commercial Court Act, Section 12 says that before making an application under the Commercial Court Act for recovery of any money, there must be a mediation. So party has to apply, have to inform the court that they have gone for a pre-litigation mediation. And if it is not done, either it has to be shown that there is an urgency, the whole remedy will be defeated unless if mediation, otherwise the suit is not maintainable. Now here also, there was a specific provision that it will, those who have not made protest cannot file a reference under section 64, read with section 77. But here the court says that since they have filed a reference, therefore that is enough that they are protesting it. They are not agreeable to receive it. They have received it without any protest. So, my lord, while the respondent argued that no protest was made, the petitioners advanced a case that seeking reference within 6 weeks from the date of award is itself the protest. Section 64, 1 of the LRR Act provides that any person interested, now my lord, he has also quoted here, which I have shown to my lords, any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for determination of the authority. As the case may be, whether his objection is to be measurement of land, the amount of compensation, the person to whom it is payable, the right of rehabilitation and settlement under so and so, apportionment among the person interested. Thus, petitioners have filed their objection as per 64, and word objection and protest are synonymous, and objection itself amount to protest. My lord, completely missed to see section 77 as well. Now, my lords, thereafter, the learned judge has cited some judgments. The petitioner have cited decisions of apex court. It has been held in as much as the appellants have filed an application for reference under section 18 of the Act that will manifest their intention. Therefore, protest against the award of collector is implied notwithstanding acceptance of compensation. Then in Chandrabhan through so and so, the principal contention urged by learned counsel for the GDA was that since compensation was accepted by claimant without any protest, the reference was not maintainable. In our opinion, this contention is without any substance for several reasons. Ajit Singh and so others. It was held that since the appellant therein has filed the application for appellants have filed the application under section 18 of the Act, it manifested their intention. Subsequently, the protest against the award of the collector was implied, notwithstanding the acceptance of compensation. My lord, all these judgments are prior to the new Act, which has enhanced the compensation manifold. And all the judgments, when there is a legislative mandate, it has a reason. And that too, Milon, in this present case, in the given fact, when right from the beginning, there is a serious dispute about one person claiming to be representing 101 landowners. So in that fact setting, this has become more important to be proved. Nothing has been proved. Everything has been presumed. So, my lord, then the court says, para 67, law is thus settled that filing of a reference application itself is enough to establish that the landowner or person interested has some objection to the award. He did not consider it fit even. Now, my lord, in those cases, it is the appellant who are the landowners. Now here, it is not the appellant, nor the appellant has come to the court either as a petitioner for reference, nor they have come in the court as a witness to support that they have filed this reference and they have made the protest. None of this fact has been considered by the trial. Because in the given facts of this case, it has become very important because none of them are personally the applicant in the reference court. It is by one person claiming to be representing them. So therefore, it has become more important to see that. Then, my lords, the respondent has also argued that in view of the deed of acceptance made as per Annexure 15 of the Land Acquisition Act, now my lord, kindly see how it has been dealt with. The landowners are barred from seeking any remedy of reference, particularly in the given fact, my lord, that it is an admitted document because it has not been disproved. Para A of this said format states, compensation accepted is conclusive settlement of all its claim of compensation. Para B provides that the question of sufficiency of consideration will not be raised. Then the deed of acceptance is exhibited by D1 as exhibit 13. The same document is also exhibited by D2 as exhibit 10. The petitioners, now kindly see, the petitioners have pointed out that the exhibit at filed by D1 bears a date of 1/11/23. That is the document I have shown to my lord yesterday. That the two documents, one did not contain the date, but the very stamp paper purchased from the treasury is 21/11/2023. And a date has been mentioned by them, and it has been posted in the court saying that it is 1/11. And without any proof of that, without getting this document to be proved, the judge has accepted. Now, he says that D1 bears a date 1/11/23, and the same as filed by D2 does not bear any date. So there were two documents of the same date, same nature before the court. With respect to one document, there were two conclusive proofs. One was when the stamp paper on which it was typed has been purchased. Now, nothing could have been more categorical and specific evidence that it could not have been of 1/11. It could have been after 20, because 20 was the date of purchase of that document. And the next document was the check containing the date 21/11. Completely ignoring those facts and those documents which was on record, the learned judge says, a perusal of the deed of acceptance make it clear that the first two pages which contain the recitals and contents of the deed, kindly see, the first two pages which contain the recitals and contents of the deed do not contain any signature of any party, even of deputy commissioner. The signature of landowners petitioners appear on a separate sheet appended to the deed of acceptance, where only their names and address with photograph is shown. Now, same thing can also be said with the exhibit 1, the power of attorney, The power of attorney also, the first page contains only the so-called recital, Then, kindly see, this, at this juncture, I would like, to show to your lordships, page 213. The judge is maintaining two parameters for the document filed by the plaintiff and for the respondent, It is not one parameter. Now, if your lordship will see page 213, this is document 1. On the first page, there is no signature of anyone. And in the next page, now, the first page is, kindly see the first page, the number A047610. First page, right side, A047610. And the second page is A047613. Not even 612, It's not in continuation. So he is accepting and believing it to all these signatures, to be part of the power of attorney, even though there is a difference in the date, etc., mismatch in signatures. So he is accepting these facts. But so far as, now, your lordship will see that so far as that part is concerned, the acceptance deed, I will just show again to my lords, And that document which I have shown to my lord contained nothing except the name and signature and serial number. And whereas at page 399, lordship will see. My lord, 399, first page is 044522. That is a stamp paper, my lords, of rupees 1000. My lord, it contains the recital. And next page is back of this page, which is the date 20/11/23 from the treasury which has been purchased. My lord, it is normally whenever any stamp paper is purchased, at the back of the first page is the signature and seal of the treasury, my lords, and signed by the treasury officer. And thereafter, my lord, again, continuation of the recital, my lords, which is coming from page 1. And on the, after completion of the recital, next page is the signature, photograph, details, address, signature of the deputy commissioner and signature of the witness. But I am putting a question to myself. Which document could have reposed confidence to the learned judge, my lord, of the trial court? Whether this document or that power of attorney, here there is no mismatch. Absolutely no mismatch. And even the signature and photograph of the wife of the deceased person is mentioned here. Your lordship have seen yesterday, which I have shown to my lords. They were all present and signed on it. But he has just simply thrown it and says that since the signature in the next page, so I don't believe this. And my lord, and then he has brought on record this document containing here the date, same document. He has produced this forged document containing the date on that. When I have shown to my lord that it was purchased on, which is on the back on 21. So he has also played fraud with the court, second fraud, my lord. That was one fraud and this is second fraud that he is saying that in his evidence. So on oath he is lying, my lord, to the court. Lord, kindly see again page 399, my lords. If your lordship will see page 399, my lord, at the top, (04522), my lord, no date may not mention here. The date is mentioned on the next page. That is the date on which it was purchased, 20 November 2023. Lordship got it, my lord? And he has filed filling up this date. And stamps are missing. My lord, if your lordship have seen, my lord, yesterday I have passed, no, there is no stamp on every page. Absolutely no stamp. This copy was given to you. Okay. So, my lord, and this is being believed by the learned judge. Lord, I'm just very quick, my lord, I will be repeating. Now, my lords, your lordship will see. So, here, my lord, he says that DW1 bears date of 1/11/23 and the same was filed, but it does not bear a date. A perusal of the deed of acceptance make it clear that the first two pages which contain recitals and contents of the deed do not contain any signature of any party, even of the deputy commissioner. The signature of the landowners, petitioners appear on a separate sheet appended to the deed of acceptance, where only their names and address. So names and address with photograph is shown, whereas on the power of attorney, there is no address, no photograph. Mismatch in the signature. There is no indication of the individual area acquired and individual company. So, and it is not disputed that the signature is not there. Individual compensation paid in the, there is no indication of individual area acquired and individual compensation paid in the said pages which bear the signature of the petitioners. Now, he has forgotten that he is accepting without any description of land or in the power of attorney, that this is our land for which claiming compensation we are executing this power of attorney. The first two pages only gives the total figure of compensation awarded to be 69 crore 10 lakhs 10,470. Then we will para 2.28 of the manual of 22 contemplates signing of the deed of acceptance after award is made. Now he comes on another aspect to cover up the first part, that award is made as per format in Annexure 15. Thus, now, my lord, then he says, on the basis of that date, we have been forgily filed in the court that thus the said deed of acceptance have to be signed after the award upon receiving the payment. However, in the present case, the deed of acceptance is dated 1/11/23. So, my lord, he is going on 1/11/23 on this. So, he is accepting this fraud. The fraud which has been played by Dagli Riba is accepted by the court as gospel truth, and relying on this date, my lord, without any proof of it, as seen in the copy filed by the Deputy Commissioner, which is before the award was made on 13/11/13, the same thus amount to making the landowner sign the acceptance deed even before the award is made. And the landowners cannot be made to accept an award even before the same is made. The right to object to award and to seek reference is born only after the award is made, and it cannot be a waiver of that right even before the same has accrued. You know, he appeared to be in very, very hurry, without any proof, accepting everything on their behalf and rejecting everything on our behalf. The PW1 in his now, my lord, kindly see, this is also very important. PW1 in his deposition and cross-examination has categorically stated that landowners have not signed any deed of acceptance. Completely false, my lord. This has not been stated by him. He says that I have no record. And the signatures were taken in a separate sheet containing only names, photographs, and addresses without mention of the individual area and compensation. Now, my lord, how can this man say so in his evidence? This could have been said only by those persons who were party to it, with whom this incident happened. How can a third party can say so? I'm putting question to myself now. Very unfortunate. They were not aware of the first 2 pages. Now, how is he presuming it? They were not aware and still signing it, including this man, Dagli Riba. The said Dagli Riba who has come to the court. Now, if that was done, he could have protested on the very next day that our signatures have been taken on with our photograph without informing us what for it is being done. None of them could come forward. None. Rightly fallen from my lords, my lord, whether after signing the settlement, this acceptance deed, did they make any application? No, none. Even Dagli Riba also did not. Either before or after that. They were not aware of first 2 pages. Said deed was filed in Exhibit 13 and Exhibit 10, and even a Schedule A and B mentioned therein. Such a statement finds support from the face of the deed of acceptance itself in view of the manner in which it has been prepared. The very format of Annexure 15 of the Land Manual of 2022 also postulates that the same should be made individually, reflecting the name of the beneficiary and the area and the amount paid. The petitioners have further submitted that even if the date of acceptance in its present form is, the petitioners have submitted that even if the deed of acceptance in its present form is taken to be executed, the same is void. The said deed extinguishes legal right to seek reference through legal proceeding. So everything which has been done by us in a bona fide manner is void, and everything which has been done by them is correct. In that event, would be an agreement in restraint of legal proceedings and would be void as per provisions of Section 28 of the Contract Act. It can be seen from para 2.28 and 22 manual that signing of deed is necessary for release of compensation. As such, the landowners would have no option but to sign the same and then object the same by filing an application for reference under Section 64. But I fail to understand where from he is getting this. Then, it is argued by the petitioner that in repealed Land Acquisition Act, Section 11(2) had provided for making a consent award as per the terms of agreement between the parties. However, LARR Act, there is no such corresponding provision in Section 23 except under Section 26(1)(c), when land is acquired for private companies or for private partnership project. The deed of acceptance executed on 1/11/23 is before making the final award on 13/11/23. It seeks to create consent as to the compensation and would be awarded later, but taking such consent is not permissible. Now, my lord, it is not prohibited. Now, my lord, that has been deleted from the provision, but that does not preclude Now, my lord, had there been such provision, then in this present case, there was no need for acquisition. Because all the landholders, including this Dagli Riba, they had agreed right from the March. And on the basis of that, my lord, Government of India decided to take this land. Otherwise, they could have gone to some other site, my lord. My lord, all these people have been benefited by the public money, huge public money they got. 70 crores they have got of the land. They have given it to the government by acquisition. Otherwise, it would have been acquisition by consent. But since there is no such provision, therefore, all these procedures have been followed, which, my lord, gives a landowner full opportunity and right at different stages if it is not agreeable to make. Now, my lord, there is absolutely no whisper. Now, my lord, this is very important, my lord, legal aspect as well as factual aspect, that this whole proceeding under Land Acquisition Act is only because there is no consensual. Consent is only with respect to 3, but then there is no prohibition. But all the procedures have been fully followed. Now, your lordship will see. As regard the deed of acceptance, the petitioners have cited a similar provision, so and so, in UP Land Acquisition Act, the issue came up for determination of the apex court. In that case, the landowners voluntarily accepted compensation by way of an agreement. The issue was that in such an event, whether reopening of the matter is permissible. It has been held that signing of agreement itself does not forfeit the right to seek revised compensation in the following words. On the basis of the above mentioned reasons, we are of the considered opinion that appellant, because of their signing of agreement, has not forfeited the right to seek revised compensation because the cause of action accrued to them much after entering into the agreement. Now, my lord, here it was not so that much after entering into the revised compensation question arose. No. At the threshold itself, it was done. It could have been done. What is very relevant to consider here is that deed of acceptance, if considered to be signed, is now, my lord, again, the judge is coming on the same fraudulent part. 1/11/23, and the award was declared on 13/11. The cause of action to seek reference can arise only after the award, and on 1/11/23, there was no cause of action in favor of the petitioner. It is relevant to note that on 1/11/13, now, my lord, 1/11/13 is the date which is only given to the court by the petitioner, Mr. Dagli Riba. The award was yet to be notified, which was later done on 13/11. And therefore, my lord, it was more incumbent to see the date, to prove which was the date on that settlement agreement, my lord, which was purchased, which deed was purchased on 2011. My lord. Notified was later done on 13/11 or 1/11. The petitioners, no, it is relevant to note that on 1/11, the award was yet to be notified, which was later done on 13/11. On 1/11, the petitioner would have no clarity about the manner and method of determination and quantum of compensation, as these are contents of the award which has yet to come. The rule of waiver of right to seek reference, therefore, cannot be attached to the right of seek reference by very language of section 64 comes after the award is made and not before. The said right certainly did not exist on 1/11 when the deed is shown to have been signed. The law is also clear in this regard that there cannot be any estoppel against law. Now, my lord, all these could have been considered only when proper evidence of all the landholders, notary public, etc., would have been done. And even by calling the Lord Deputy Commissioner and other officials, including the Treasury officer, when this was sold, nothing has been done. The respondent number 2 to 5 also argued that the land being acquired under urgency clause as per section 43, 80% that 80% compensation was earlier given. Even at that stage, no protest was lodged. 43 requires payment of estimated amount which is identical to provisions of section 73A of 89 Act, 1894 Act. The word estimated has been interpreted by the apex court in Lakshmi Devi versus so and so. Thereafter, my lord, certain judgments have been cited. And then the next page, 79, my lords, page 107. The petitioners have argued that there is no provision for making objection as per statute when 80% compensation is given and the same is based on an estimate only before the award is made. Now, my lord, this could have been, my lord, viewed by the learned judge with reference to the assessment sheet which was filed by all of them. So they had all knowledge about that. The right to object comes after the award is made. In this case, the award was made on 13/11, and after disbursement of the compensation, the objection in the form of reference application was duly filed. The said contention finds legal support from the decisions of the apex court. Provision of section 64 of the LRR Act gives available landowners to object an award, and the provisions of the manner given in this statute. Such legal rights therefore cannot be taken away by the instructions or executive notifications like the notice. Lord, it was not on that basis. It is under the provisions of LRR Act, Lord, section 64 and 77 proviso. LRR is a self-contained code which statutorily provides landowner a right to object and approach the court at a given stage, and such statutory right would have prevailed. One of the argument of learned counsel for the respondent number 1, that as per Exhibit 3, the landowners were aware of the rate fixed in the assessment C, and they agreed to the acquisition of the land. In this regard, acquisition of land for defense and consent of the landowners has no relevancy. Now, my lord, in law it may not be, but in fact it has. As it is acquired for urgency under section 40 of the Act, and the law does not disallow the landowners to claim for adequate compensation, even if they were aware of the rate given in the so and so. Accordingly, they have demanded the fair compensation. If such prayer is not allowed, the subject and object of law will be defeated. Accordingly, the submission is rejected. Hence, the issue is answered. So, my lord, these are the two issues, my lord, which goes to the root of jurisdiction. And therefore, my lord, as a preliminary issue, my lord, before your lordships, I have made my submissions on these issues. Now, my lord, if these issues, my lord, find favor by your lordships, my lord, everything will become redundant, my lord. And I did not go into all other issues, my lord. So, my lord, I would be requesting your lordships, my lord, so that the other side may respond on these issues, my lord. And thereafter, the lordship may decide on these issues. If the reference is not maintainable, then everything is so. Then it can be done in accordance with law, if as permissible in law.
Okay. Yes, Mr. Pathak.
My lord, I have heard at length, my lord. Of course, as I understand now, what is the matter that is being formulated is that though in trial court we normally have a situation where a preliminary issue at times can be framed, and that decision at times is taken before the other issues in the suit are decided. But in appeal, my lord, I don't think there is any such provision. Of course, your lordship can make exceptions to that. But then there's no such provision that a preliminary issue would be heard separately and the rest of the issues should be argued thereafter. So tomorrow, if your lordship comes to a finding that these issues are, as raised by the appellants, are not tenable and the decision is in our favor, then whether lordship will write another judgment to explain or give them another chance to, my lord, argue the rest of the points as far as rates are concerned. That is one thing. But then, of course, if your lordship wants to split up the hearing on issue-wise basis, we can proceed on issue-wise basis that he will argue one issue, I will respond to one issue, then lordship can proceed to another issue, and then we will argue one issue.
But if the party is not willing to press those issues, the court cannot compel them to argue on that.
Definitely. It's up to the court now to basically how to modulate the argument, because there is no set procedure as such.
Okay. If necessary, we will list the matter in the to be spoken column, if necessary,
My lord.
later on.
My lord.
Okay, heard Mr.
My lord,
S.D.
I
Sanjay, learned Additional Solicitor General of India, assisted by Mr. Y. Dolo, learned Senior Counsel, and Ms. P. Ahuja, learned counsel for the appellant in LA Appeal number 1 AP 2024, and also heard Mr. Pathak, learned counsel for the respondent, Mr. Rirampo. Respondent number
104 and 105.
104 and 105. And you?
I mean, item number 16, Your Honor. Item number 16, connected appeal, Your Honor.
Connected.
That appeal is yet to be admitted, Your Honor.
Next appeal.
Yet to be admitted, Your
Honor. That can be segregated because that is an appeal filed by the state of Arunachal Pradesh.
And the Deputy Commissioner, Your Honor,
and the
who
Deputy
initiated the whole acquisition proceeding and completed
Okay, then we will segregate the matter.
Not
Okay. Heard in part, list the matter, Mr. Pathak.
My lord,
At the earliest, my lord, I would be requesting.
next week, my lord, it can be on Tuesday or Thursday, my lord, as per the
Tuesday.
convenience of the court.
Tuesday
As per the convenience of the
we
court,
have, Tuesday we have DB matter also.
my lord. Thursday then, my lord.
Thursday, no, Thursday same thing.
When I will try on Wednesday then, my lord. With due convenience of the court, my lord. I'll try on Wednesday.
4th of June.
Yes,
Not
next month, my lord.
Fourth
Okay.
is,
Okay.
what is
4th of
Wednesday?
June.
What is Wednesday, my lord? That is what I answered.
Yes.
Fourth.
4th of June.
Okay.
Grateful, my lord.
List the matter is parted. The other method being WPC number.
LA.
No, so LA appeal number 4 AP 2024 stands segregated from this LA appeal number 1 of 2024. Any other matter?
Your Lordship, may I submit your Lordship for item number 8, my lord?
Deeply grateful.
Your Lordship.
Item number 19.
Okay, we'll call it.
May I, Lordship? I have confusion, Your Lordship, whether my matter is fixed on 4th or it will be fixed on.
No. We have segregated the matter. We will pass separate order now.
Separate order. Okay.
Yes, next matter.
And we are not the party, my lord, in that.
Okay, all right.
But we would have been necessary party because it arises out of the same proceeding. The deputy commissioner has come in appeal, and even though we were necessary party, we have not been made party.
Okay, we'll see.
Lordship.
If necessary, we'll direct them to implement you as party.
Lordship.
Your Lordship, I am appearing in item number 8.
Order?
In item number 8, Your Lordship, I am appearing on behalf of petitioner. This is a petition for quashing of the proceeding filed by respondent wife under the provision of Domestic Violence Act.
So, Talo, you were here?
My lord, I am for the respondent, my lord, in item number 8.
8.
My lord, AR 8, 9, 10.
Who is for the state respondent?
Actually, in item number 8, there is no state, my lord. In item number 9, there is.
Private complaint.
Yes, my lord. Item number 9, there is the state was there. S, special PP, SIT.
So, this matter is ready for hearing,
Yes, my lord, it is ready for your.
but today time will not permit. Heard, Mr. Your good name, please.
Rohit Jagwani, Your Lord. My lord, may kindly fix for day after tomorrow.
Day after tomorrow.
Lordship, in regards, there have a small prayer, Lordship. I will be not in station, so can it be fixed on Monday, Lordship? 2nd June.
Monday.
Monday.
Yes,
My lord.
Monday.
Yes, my lord.
Mr. Swenson, learned counsel for the petitioner, and also heard Mr. Talo, learned counsel for the respondent. As agreed by learned advocates of both the parties, recess and list the matter on Monday, next Monday.
Lordship, if I may, Lordship. Lordship, in item number 10, there is an interim order that may be kindly considered.
Item number 10,
Yes, Lordship. Criminal petition 212, Lordship.
criminal petition number 212.
212 of 2022, Lordship.
Okay. Who is in 212? Who is the petitioner?
Herein I am the petitioner, Lordship.
You are the petitioner.
Yes, Lord.
Heard Mr. Talo, learned counsel for the petitioner. None appears for the respondent on the call.
Your Lordship, I am appearing for respondent, my lord.
He is the respondent.
I am for respondent.
Yeah, state is the party?
No, Lordship. It's a private.
Okay. And Mr. So-and-so, learned counsel for the respondent. Place the matter on same day.
2nd June, Lordship.
In IA, you take down, interim order passed earlier, shall continue.
Much.
All like that.
May I, Lordship, the pleading are completed, are complete, so therefore the matter may fix for admission here.
Service complete.
Yes, pleadings are complete.
Okay.
Pleadings are
Third,
complete.
Mr.
Yes. N. Kuru,
Learned counsel for the petitioner,
on behalf of N. Dangen.
appearing on behalf of
N. Dangen.
and
N. Dangen.
Dangan, learned counsel for the petitioner. Then Mr. Rizam for state respondents. It is submitted at the bar that pleadings have already been completed and the matter is ready for admission hearing.
And your Lordship,
Accordingly, it is provided.
in the meantime, your Lordship may grant liberty to file an affidavit in reply.
Pardon?
In the meantime, your Lordship may grant liberty to file an affidavit in reply if required towards respondents.
You want to file affidavit in reply?
Yes, if required, Your Lordship.
Okay. Admission hearing. On the pair being made by learned counsel for the petitioner, liberty is granted to him to file affidavit in reply.
Yes.
Your Lordship, this matter was fixed for hearing today.
Yes. Are you ready for hearing?
Yes.
But Lordship, conducting counsel for the respondent, Mr. Pangin,
Left.
he's not feeling today, not well today, Lordship. So he left the court, Lordship. So kindly this
When?
matter may be taken up tomorrow, Lordship.
Tomorrow?
Tomorrow, Lordship.
Yes?
No.
No objection.
It is fixed.
Tomorrow?
Yes.
Okay. Hard miss your good name?
E-permit.
Pardon?
E-permit.
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 Learned counsel for the petitioner. And Mr.
V. Lona.
D. Lona.
Lona. L-O-N-A.
Learned counsel for the respondent. As agreed by learned advocates of both the parties, this shall raise the matter tomorrow.
God bless.
Okay.